Hi everybody, this is Alex again from the UPS store. Maybe I can let you in on a little secret. Did you know we're open on Sundays? Yeah, since February, probably one of the best kept secrets in Crestview, we're open on Sundays from 10 until 3 p.m.
Congratulations, Dixie Dan Powell, for your recent induction into the National Trial Lawyers Top 100. The National Trial Lawyers Top 100 is an organization celebrating premier trial lawyers from across the country who meet stringent qualifications as civil and/or criminal defense lawyers.
At Powell, Powell & Powell, we are a family of lawyers working together as a team for our clients. For more information, visit us online today at www.powelllawfirm.com.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office on North Verdon Boulevard for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestview.agent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
Hi, I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hi everybody, this is Alex again from the UPS store. Maybe I can let you in on a little secret. Did you know we're open on Sundays? Yeah, since February, probably one of the best kept secrets in Crestview, we're open on Sundays from 10 until 3 p.m.
Congratulations, Dixie Dan Powell, for your recent induction into the National Trial Lawyers Top 100. The National Trial Lawyers Top 100 is an organization celebrating premier trial lawyers from across the country who meet stringent qualifications as civil and/or criminal defense lawyers.
At Powell, Powell & Powell, we are a family of lawyers working together as a team for our clients. For more information, visit us online today at www.powelllawfirm.com.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office on North Verdon Boulevard for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients, at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview, or shop online at hubcitysoapery.com. Hub City Soapery.
Hi, I'm Amanda Gaskin with Briarpatch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hi everybody, this is Alex again from the UPS store. Maybe I can let you in on a little secret. Did you know we're open on Sundays? Yeah, since February, probably one of the best kept secrets in Crestview, we're open on Sundays from 10 until 3 p.m.
back in session.
Thank you. Please be seated. 10:03, did you read the administrative directive or order? Yes, sir. Thank you, sir. On the 130 docket, first I have Jesse Cost, 23 CF 312. We'll pass him for a little bit and hopefully he shows up. If he doesn't, then we'll come back and address him. Mr. Barnes?
First, I'll have Eric Lucas, followed by Aaron Martinez.
And I do see some other pro se's and all. And these folks that aren't represented, I'll call them next. Rachel, what case do you have?
Good afternoon, Your Honor. I'm here to assist Mr. McKinney with Rodriguez Graciano Crescencio. He's not in the courtroom yet.
Okay, so he's on the 130 docket?
Yes, sir.
You'll let me know when you're ready.
Yes, sir.
Thank you.
Your Honor, this is Eric Lucas and 23 CF 265. We will acknowledge receipt of the one-time information, waive the formal reading, enter a not guilty plea, and ask that this remains set on the May 8th docket.
Okay. Mr. Lucas, I'll see you on May 8th at 9 o'clock, okay?
9 o'clock. Thank you, Your
Thank you, sir.
Next, I have Aaron Martinez, followed by Jeremy Mobley. Your Honor, this is Mr. Martinez. We will acknowledge receipt of the 3-count information, waive the formal reading, enter a not guilty plea, and ask that this remains set on the 5-8 docket.
Mr. Martinez, I'll see you on May 8th at 9 o'clock. Make sure you stay in touch with Mr. Clark. Thank you, sir.
Next to be Jeremy Mobley, followed by Ashley Murray Swan. This is Mr. Mobley, Your Honor, in 23 CF 354. We have receipt of a 2-count information. We will enter a not guilty plea and ask that this remains set on the May 8th docket.
Mobley, I'll see you on May 8th at 9 o'clock.
Look forward to it.
Thank you, sir.
This is Ashley Murray Swan. She'll be followed by Gregory Murphy. Your Honor, in 23 CF 359, Ms. Swan is before the court. We will acknowledge receipt of a 1-count information, waive the formal reading, enter a not guilty plea. And she does have another case, 21 CF 3284, which looks like it's probably already on the May 8th docket. I would just ask that both cases be on the same May 8th docket.
Okay. Ms. Murray Swan, I'll see you back here on both of your cases on May 8th at 9 o'clock. Thank you, ma'am.
Okay. Gregory Murphy. Is he in there?
Yes.
Oh. Next I have, Your Honor, would be Emmanuel Pride, followed by Marcus Pride.
Oh, Mr. Brown.
Your Honor, this is Mr. Emmanuel Pride in 23 CF 258. We do have a 3-count information we will acknowledge receipt of, waive the formal reading, enter a not guilty plea, and ask that this remains set on the May 8th docket.
Mr. Pride, I'll see you on May 8th at 9 o'clock. Stay in touch with Mr. Clark. Thank you, sir. Oh, Mr. Pride.
This is Marcus Pryor in 23 CF 356. I talked to Mr. Gomez this morning. I believe the state has an announcement.
Your Honor, at this time, based on the request of the victim, we are going to be announcing an Okaoosa in this case.
Mr. Pryor, your case is dismissed.
Okay.
Thank you, sir.
You
too.
Judge, I have Elisa Rios Penalosa. She's approaching in 23 CF 318. We would acknowledge the receipt of a 3-count information, waive its formal reading, enter a plea of not guilty. This is already scheduled for the 8th of May at 9 o'clock.
I'll see you May 8th at 9 o'clock.
Thank you.
Thank you, ma'am.
Donnie Root, followed by Vince Rump.
Hello, Mr. Root.
Mr. Root is here in 23 CF 233. We would acknowledge the receipt of a 2-count information, waive its formal reading, and a plea of not guilty. This is already set for May 8th at 9 a.m.
Mr. Root, I'll see you May 8th at 9.
Yes, sir.
Thank you.
Vince Rump. Mr. Rump is present. In 23 CF 352, we would acknowledge the receipt of a 1-count information, waive its formal reading, and a plea of not guilty. This is also set on May 8th at 9 a.m.
Mr. Rump, I'll see you back here on May 8th at 9. Stay in touch with Mr. Klein, or Mr. McKinney.
All right, thank you, sir.
Thank you, sir.
Come in and see me, so, and then they give me more on the bad address. I have a copy of it. Jared Benson. Followed by James Wade.
Hello, Mr. Vincent.
Mr. Vincent is present in 23 CF 251. I would ask the state if there was an offer for today for Mr. Vincent.
Judge, the offer for today would be an adjudication of guilt and credit for time served, $615 in court costs, and a public defender fee if applicable. My understanding is that Mr. Vincent has some prior felony history.
Judge, I've discussed it with Mr. Vincent. He wishes to enter a plea of no contest as charged to the 3-count information. As stated, if I restate, the offer would be for time served, court costs in the amount of $615 or $150 cost of defense. With the adjudication of guilt, Mr. Vincent has previously been adjudicated guilty of a felony in the past. He would ask for 6 months to pay off those amounts before they are sent to collections.
Thank you. Mr. Vincent, if you'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down. Mr. Vincent, the main thing I was listening for from Mr. McKinney was if you had previously been adjudicated guilty. Because if you hadn't, I wanted to make sure that you understood that downside. Do you understand that if I accept your plea, that you're waiving your right to a trial by jury?
Yes.
Do you have any questions for the court or your attorney or the state?
Mm-hmm.
Mr. Vincent, I do accept your plea. You're adjudicated guilty. You're sentenced to credit for time served. All monetary assessments mandated by statute or county ordinance are imposed. That's the court cost. There's also a $150 public defender's fee. If you fail to pay those within six months from today, then they will go to a civil lien or judgment. Thank you, sir.
Thank you.
May I approach with the score sheet, Judge?
Yes, ma'am. Thank you.
Judge, this is James Wade.
Hello, Mr. Wade.
Mr. Wade is here in 23 CF 276. We would acknowledge the receipt of a 2-count information, waive its formal reading, enter a plea of not guilty. This is scheduled for the May 8th pre-trial court date. He would need to be here at 9 a.m. for that court date.
Mr. Wade, I'll see you back here on May 8th at 9 o'clock, okay?
Yes, sir.
Thank you, sir.
An appointment, come in and talk to me. And Judge, I would ask Madam Interpreter to call for the interpreter case.
Rodriguez Graciano Crescencio.
Madam Clerk, you'll swear in the gentleman.
Do you swear or affirm that you will make an accurate, complete, and impartial interpretation of the Spanish translated into the English language, vice versa, relative to the cause and consideration before the court?
I do.
I am Jason McKinney, and I represent Mr. Crescencio Rodriguez Graciano. And Judge, this is a two-count information. Count one is a lead in the scene of a crash with injuries. Count two is driving without a valid driver's license. For today, we will enter a plea of not guilty. We will waive formal reading of the charges. This is scheduled for May 8th at 9 a.m. He would need to contact my office and schedule an appointment. And I'm providing my contact information at this time.
Mr. Rodriguez Graciano, I will see you back here on May 8th at 9 o'clock. Make sure that you make an appointment with Mr. McKinney and attend that appointment before that date. Thank you, sir.
That is all I have, Your Honor.
Thank you, Teresa.
Thank you, sir.
Yes, ma'am.
Jeffrey Ross. Mr. Ross is present in 23 CF 346. We would acknowledge the receipt of a one-count information, waive its formal reading, enter a plea of not guilty. This is scheduled on May 8th at 9 a.m.
Thank you. Mr. Ross, if you'll hold in 1 second.
I was just here 2 days ago.
Okay, that's what I was trying to figure out is what.
I have no idea.
A misdemeanor? You want to show it to Mr. McKinney? Thank you.
From Crestview. Because it's a Crestview case going back to 16th of February. I don't know if anything.
I don't know that.
Is there like when my mom lives in the
Okay.
parking lot?
Yes, hold on 1 second, Allison. I'm hearing Mr. Ross, hold on 1 second, Mr. Ross. I don't want you to say anything that'll hurt your case, okay? Mr. McKinney, hearing the excited utterance of Mr. Ross, it said, I was just here 2 days ago, to the state, and Mr. Ross is here today. If the court gives him an ROR on that bond,
Judge, I'm not really even sure what the charge is because I haven't seen the warrant, so.
For a Crestview misdemeanor case? He was in court for another felony case in front of Your Honor on Monday for pretrial is what he was talking about. That doesn't look like that specifically relates.
hold tight, let's see what we can do.
Okay.
Mr. Ross, it just means a lot to the court that you're here. You were here earlier this week. You're here now.
Yes, sir.
2980.
The court minutes show that he didn't appear for the case starting this week.
Yes, ma'am.
Okay.
Yep. That's what we were just talking about. Thank you, though.
So, to the state, any thoughts?
Judge, I don't necessarily have a problem with a ROR bond. It looks like he's got a petty theft. I think there's a little bit of issues because there's two separate petty thefts that have two separate court dates, but it looks like he failed to appear according to the clerk minutes for both of those cases. So there should be another warrant as well from 313 that's coming out as well.
Withdrawn on here.
And 313 was the day he was in court. All day in pretrial, too.
Right. But I guess he was supposed to be downstairs as well for misdemeanor court at that point.
But it's okay. I know you were here all day.
Do you have a case number? Okay, tell me the case number. 2, and what's the other one? 2930.
As Your Honor probably heard from Madam Clerk, one of these is for Monday, which was also Your Honor's pretrial. Mr. Ross was present for that pretrial as well.
So, Mr. Ross, I'm writing on here ROR bond for both of those case numbers.
I appreciate it, thank you.
So
I will be here. I had no idea.
They're still probably going to take you out that door. So you just sign yourself out.
right, that's fine, as long as there's a record.
I have
So, Mr. Ross, I think they'll still need you in the back, but you'll be able to sign out, okay?
Okay.
And on this case that you were here for, I'll see you on May 8th at 9 o'clock. Stay in touch with Mr. McGee.
How do I find out when to come for these other?
Contact me.
Okay.
As soon as you get out.
But it's my understanding there's one this coming Monday, or was that the last one?
Last
Monday.
Last Monday. Okay, good. So talk to Mr. McKinney.
Okay, yes, sir. Thank you.
Thank you, sir.
Judge, the remaining individuals I have in custody to courthouse to do that.
Okay, I think we were going to, if Allison came out, we were going to do the juveniles because they cut them. You want to do the juveniles?
Sure.
Okay.
Well, they're processing.
Okay. Then I'll call the pro se's, okay?
He said,
Do you want the juveniles now? Okay, please. And then after the juveniles, then I'll call the defendants that are in the gallery that aren't represented. Gotcha. 23 CF 322.
Your Honor, this is Mr. Jamarian Pride. I have a note on my file that there's been a bond motion filed in this particular case. However, the note, and I did not write this note, it looks like my assistant did, it indicates that there may be a transfer to Division 1 of this case, and the bond motion hasn't been noticed for a hearing because of the transfer issue. So I was asking the state just now, I don't know.
It looks as though there was something, I think it is going to Division 1, yeah, so that's why I have it.
Is there a co-defendant that has a lesser?
Yes, there's 4 co-defendants actually. I have, I think, all of them.
Okay.
So, this is the one here with me.
So to the state, do you want to make an oral motion to transfer?
Yes, please, if we can make a motion to transfer it to Division 1. Have you guys allowed to?
Your Honor, I was just talking to Mr. Pride about, he had, to his credit, had brought up the 40-day rule. And I was confirming with Mr. Gomez, it looks like the state filed an information on February 7th, which is within the time limit. So we'll enter a not guilty plea of the formal charges, and we'll just wait. As soon as this gets transferred to Division 1, we'll notice that bond motion for hearing in Division 1.
And the state just made an oral motion for that. Any objection?
No objection at all.
So, Mr. Pride, I do grant the motion to transfer, so you'll appear in front of Judge Ketchel, okay, with the other co-defendants.
And what I'll do when I get back to the office, Your Honor, is we will notice this for a hearing today in front of Judge Ketchel on the first available day.
Okay, good. Thank you, Mr. Pride. Thank you. Hello, Mr. Pride. Mr. Stevens represents you, and I don't see Mr. Stevens. I don't know if he was just... Okay.
I don't have his information. He may have filed a written plea or not.
Is there one? Okay, but he didn't file a written plea. Okay. Mr. Pride, David Stevens is going to be representing you, so he'll come and see you in the jail to make sure that you two get together. I'll continue this hearing until the next arraignment that I have, which is March 23rd. Today's March 23rd. Okay, so next week I'll see you and make sure that you get together with Mr. Stevens.
Yes, Your Honor. Thank you.
Sir. Thank you.
Thank you, Your Honor.
Thanks, ma'am. Okay, the other proceedings. Did Jesse Lacoste ever appear? 23 CF 312. Mr. Lacoste, you're charged with larceny contracting. I think it's $20,000. I'm looking at the summary. Let me pull up the actual document. To the state.
Yes,
So it's contractor fraud, money received by a contractor between $20,000 and $200,000, correct?
That's correct, Your Honor.
So, Mr. Lacoste, do you wish for me to appoint a public defender if you qualify financially, or do you intend to hire a private attorney?
I intend to hire a private attorney.
Okay. Mr. Lacoste, I'll see you back here on May 8th at 9 o'clock. Make sure that you hire your attorney sooner than later so that they can help you on your case. Talk to the state before the 8th, okay?
Thank you.
Thank you, sir. So I enter a denial for Mr. Lacoste. Next is Robert Mathias. Robert Eugene Mathias III.
Yeah, he's in jail.
Okay, thank you. Okay, I'll call the folks that are out. I'm sorry. Carl Burkett, 23 CF 340. Come on, Mr. Burkett. Come on up. Does the state have an offer for Mr. Burkett? Does he need an attorney?
Your Honor, I would represent Mr. Burkett in a different case.
Good. Thanks, Mr. Walton.
I would ask the court, since we already represent Mr. Burkett, to appoint us to this particular case.
Mr. Burkett, has your financial condition gotten any better since you were previously appointed public defender?
Yes.
Okay. I do appoint the public defender to represent you on this case.
Your Honor, we do have receipt of a one-count information. We will enter a not guilty plea. Ask that this remains set on the 5-8 docket. Mr. Burkett's other cases are on that docket.
Good. Mr. Burkett, I'll see you on all your cases on May 8th at 9 o'clock.
Thanks, sir.
Thank you, sir. Edrin Sanders, 23 CF 337. Oh, Mr. Sanders. Mr. Sanders, you're charged with vehicle theft. That's why you're here. Do you wish for me to appoint the public defender if you qualify financially?
Yes, sir.
How much money do you make per month?
A little over like $1,500 a month.
Okay, I do appoint the public defender to represent you. Mr. McKinney's approaching on your right.
Judge, I'm providing my contact information at this time. We will acknowledge the receipt of a one-count information, waive its formal reading, and our plea of not guilty. This is already set for May 8th at 9 a.m.
Mr. Sanders, I'll see you May 8th at 9. Stay in touch with Mr. McKinney.
Yes, sir.
Thank you, sir.
Yes, sir.
Andrew Byron Scott, 23 CF 334. Hello, Mr. Scott. Mr. Scott, do you intend to hire a private attorney, or do you wish for me to appoint a public defender if you qualify financially?
I'll hire a private.
Okay. So, Mr. Scott, you're charged with aggravated child abuse, by aggravated battery. That's why you're here. I do enter a denial for you. I'll see you back here on May 8th at 9 o'clock. Hire your private attorney sooner than later so they can talk to the state. Okay. Thank you, sir. Nicholas Sheeler is next, 23 CF 325. Oh, Mr. Sheeler. Mr. Sheeler, you're charged with domestic battery by strangulation, domestic violence battery. That's why you're here. Do you wish for me to appoint the public defender if you qualify financially?
Yes.
How much money do you make per month?
Between $2,000 and $3,000.
Okay. You may not qualify for the public defender. You'll need to fill out a financial affidavit. You have one up here.
At the moment, I'm not working. I'm in the pre-hire process.
Okay. How long have you been unemployed?
For about 2 weeks.
Okay. If you'll fill out that financial affidavit, provide it to the deputy before you leave. If the clerk says that you don't qualify financially, I encourage you to appeal it to the judge. There's a place at the bottom that you can send it to us. We have a little more discretion than the clerk does, so let us look at it and see. If you qualify, then we'll let you know, and you can get in touch with the public defender. If you don't, then you'll need to hire a private attorney, okay? In any event, I'll see you back here May 8th at 9 o'clock.
And I turn this right into the clerk?
Fill that out in the gallery and then hand it to the deputy. Yes, sir. Okay. Thank you. And I do enter a denial for Mr. Sheeler. Cody Sikora, 23 CF 238. Hello, Mr. Sikora. Does the state have an offer for Mr. Sikora?
Not for today, Judge. It's an S&D.
Yes, ma'am. Mr. Sikora, do you wish for me to appoint a public defender if you qualify financially?
Oh, yes, please, if you would.
Okay. How much money do you make per month?
Not enough. I couldn't tell you off the top of my head.
What do you think?
Not maybe 2,000 on a good month.
Okay,
Not
I do
enough.
appoint the public defender to represent you.
Thank you.
Mr. McKinney's on your right.
Judge, I provide contact information, Joseph McKinney from the Public Defender's Office, will acknowledge the receipt of 2-count information, waive its formal reading, and or plead not guilty. This is already set for May 8th at 9 a.m.
Okay. Good deal.
This is for May 8th, 9 o'clock.
Yes, sir. Thank you.
Thank you, sir.
Make an appointment.
Yes, sir.
Okay, I think that's all the pro says. To the attorneys, well, Mr. Dyer, do you have somebody on the 130?
Your Honor, I have Jason Coe. I believe he was noticed for 1:30. It's a bond hearing. I don't know if you want to wait.
Yes, sir, let me see if I can get the other folks that are in the gallery for 1:30 to the PD.
He also has, on the 2:30 docket, he also has Mark Whitley, but I think we're prepared to enter a plea on that case, and my victim's also present, so I need for her to also sit around.
Okay. You wanted to take the plea?
Not what, Your
Okay.
Honor.
Mr. Dyer?
Can I get a witness from
And then to the PDs, is there any other defendants in the gallery that you want to take next?
I don't have anybody. I know she's here for Mr. Madrigal. So.
They're here for the Xavier.
Your Honor, Mr. Whitley is present and approaching in 21 CF 648 and 22 CF 1498. In 22 CF 1498, he's going to withdraw his earlier plea of not guilty, enter a plea of no contest. And in 21 CF 648, he is going to admit the violation. May I approach with a written plea, Judge?
Yes, sir. Mr. Whitley, if you'll raise your right hand. You swore to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
Thank you, sir. You can put your hand down. Mr. Whitley, did you read the plea agreement?
Yes.
Do you understand?
Yes.
Did you discuss it with your attorney?
Yes.
Did he answer all of your questions?
Yes, Your Honor.
Are you satisfied with his representation?
Yes, Your Honor.
Did you sign the plea agreement?
Yes.
Mr. Whitley, I do accept your plea. You're adjudicated guilty in the 21 CF 648 case. Your supervision is reinstated and modified so that the next 1 year is community control and the balance of your supervision will be probation. All the original terms and conditions are reimposed. You'll need to pay the $100 cost of prosecution. In 22 CF 1498, count 2 is dismissed. Count 1, you're adjudicated guilty of the lesser included offense of misdemeanor battery. All monetary assessments mandated by statute or county ordinance are imposed. That's the court cost. You'll get your sentence to credit for time served. Okay, I've got a second count 1. What is that talking about?
I think he's just addressing the adjudication, and
Because on the VOP judge, he got a withhold, and he will maintain that. So I just wanted to make it clear that he was only being adjudicated guilty of the misdemeanor battery.
Okay. So the violation of probation is still a withhold?
Correct, Your Honor.
Good. Thank you. Thank you, sir. Good luck to you.
Thank you, Your Honor.
Judge, to be clear for the record, I have spoken to my victim in that case, and she is in agreement with this resolution as well.
Okay. Thank you. Mr. Shealy, come on up. Based on your affidavit saying that you don't have any money and everything else that you've filled out, I do appoint the public defender to represent you.
Thank you.
Mr. McKinney's approaching on your right.
Judge, I'm providing my contact information at this time. We will acknowledge the receipt of two-count information, waive its formal reading, and I plead not guilty. This is scheduled for May 8th at 9 a.m. for pre-trial.
So I'll see you back here May 8th at 9.
Thank you.
Thank you, sir.
Your Honor, I have the case lined up. You just go straight down and then if they do on motion, that should be it.
We wanted to do the one case sooner than later.
Your Honor, I don't think, Deputy Nash is not here yet, so I'm okay.
If you'll let me know when you're ready. Okay. Good. Thank you. Yes, ma'am.
Ms. Lewis?
Judge, I think Ms. Lewis is set on the 3:30 document.
Well,
Go back.
I mean, as long as she's
Attorney's
good.
not here yet, Judge.
Oh, okay. Sorry, Miss Lewis.
It's okay. Ramirez?
Judges, it's Ms. Kayamara Ramirez, did I say that right? Kayamara, I will mess that up every time, I promise. She's here in 23 CF 226. Has an information been filed in this case?
It's getting transferred to Mr.
Ramirez?
Mayor's court.
So that's good news for you. No, there was something totally different. What we're talking about is transferring the case into county court, so that we do file in county court for the last file. So, okay.
Can you pronounce your last name how?
Ramirez.
Great. Thanks, Mr. Ramirez. When Mr. McKinney said you're getting transferred to another court, that's a good thing for you. I thought, wait a minute. I thought he meant transfer to another circuit judge, but then I heard county court, so that is a good thing for you. So you'll have another arraignment.
But county court's definitely a better result for you.
Right.
You're going to have to deal with this more.
Thank you, ma'am.
This is Malika Turnage.
Yes, sir.
As a control day, I think that'll be fine. Judge, this is Ms. Marcia Turnage before the court in 23 CF 237. Has an information been filed in this case?
On the 2nd March.
I don't have one here.
Judge, Ms. Turnage is here, and we acknowledge the receipt of a two-count information. We waive its formal reading. We enter the plea of not guilty at this time. And speaking with Ms. Turnage, I know that she wants to receive the discovery as quickly as possible, especially the body camera footage of the event, so that I can review that with her. Her next court date would be May 8th at 9 a.m. But if we were able to reach some sort of an agreement ahead of that May 8th date, I'd like the opportunity to advance this on the docket.
Absolutely. Yes, sir. Ms. Turnage, I'll see you no later than May 8th. But if your attorney wants to have a motion heard before that date, or if you want to enter a plea, then I'll see you before that. Okay? Thank you, ma'am.
Can I say something?
You tell it to Mr. McKinney away from the microphone first, okay?
Judge, she was inquiring of me what we just talked about, and I'm going to be filing the bond motion for Ms. Turnage. Ideally, I would want to get the discovery and be able to review that ahead of that bond hearing, but I will set that on Your Honor's next available date.
Okay. Thank you, ma'am. I'll see you then.
Next is Richard Mandolini.
Okay. That's why I sent that. Okay. That's why I sent that. Okay. Your Honor, this is Mr. Richard Mandolini in 23 CF 273. Mr. Mandolini is going to accept the state's plea offer at this time. The agreement is that Mr. Mandolini would enter a no contest plea as charged. He would be sentenced to 2 years of regular probation, be assessed $615 in court costs, $150 of public defender fees. He's also going to perform 24 hours of community service, have a substance abuse evaluation within 30 days, beginning recommended outpatient treatment within 60 days, and he would be adjudicated. And it's not on the plea form, Your Honor, but I believe there's going to be no trespassing at the Walmart. Give me 1 second.
Traditionally, all Walmarts.
Correct. Just don't go to Walmart. Start shopping at Target. All right.
May I approach?
Yes, sir. Mr. Mandolini, if you raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. You can put your hand up. Mr. Mandolini, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
Mr. Mandolini, I do accept your plea. You're adjudicated guilty. You're sentenced to 2 years probation. Okay, so that's going to be on the felony counts.
We just asked for time served on the misdemeanors.
Time served on the misdemeanor count.
Correct.
All monetary assessments mandated by statute or county ordinance are imposed. That's the court cost, $150 public defender's fee, $40 per month cost of supervision. You'll need to perform 24 hours of community service work, submit to a substance abuse evaluation within 30 days from today. If any treatment's recommended, begin that within 60 days from today. Also have no trespassing at any Walmart.
Okay.
Thank you, sir. Good luck to you.
Thank you.
Right over here, sir. Next is Robert Mathias.
Ms. Lyons, how you doing? Good. Well, does the state have an offer to Mr. Mathias?
Yes, Your Honor, the adjudication of guilt, 2 years of probation, substance abuse evaluation within 30 days, and treatment recommended within 60 days, and then 48 hours of community service work.
Your Honor, I'd like to say something, if that's okay.
Yeah, wait, hold on one second.
Yes, sir.
Don't want you to say something that'll hurt your case. So here's what your options are. You can accept the state's offer, waive your right to an attorney, waive your right to a trial by jury. You'd be on probation for 2 years, have to do those other terms, and we talk about that. You'd get out of jail today. Or I can appoint a public defender if you qualify financially, or you can hire a private attorney. If you say whatever you want to tell me on the record, it can be used against you if it's about your case.
It is about the case, and it will not hurt me.
Okay, it's up to you.
Yes, sir. I've already went in front of a judge. I can't remember the judge's name for a first appearance while I was in jail for these new charges.
Yes, sir.
It was unanimously decided by the judge, the state's attorney, and my public defender, who represented me at the first appearance, that there was no probable cause and I was released. Okay, now the reason why I'm here is for a failure to appear on the violation that was a product of said new charges. But I was unaware of that court case. It was sent to an address that I haven't lived at in 8 months. So, I mean, it would be absolutely absurd for me to accept this deal when I know that there's no probable cause. You know, I didn't break any crimes, so therefore there is no violation.
Okay, so you want a public defender?
Yes, sir.
Okay. How much money do you make per month?
As of right now, I just got an LLC. My company is very new, and I do not have any funds right now. But I would like to know if I can make a bond or have a personal signature bond.
Okay. How long have you been unemployed? I understand you have a separate entity, but...
It's been a couple months.
Okay.
Yeah.
And how much money were you making per month before that?
Not very much. I was working for a labor day-by-day place.
Okay. I do appoint the public defender to represent you. Mr. Kleins is coaching on your left.
Okay.
I did hear what you said about a bond.
Yes, sir. I just, with this...
How long have you lived in the area?
I've been here for over 10 years. I'm no flight risk.
Family here?
I have a twin brother here. I have my son here, and I have my son's mom here.
Okay.
Your Honor.
Yes, sir.
Mr. Mathias does appear to be correct. Not that I wasn't there at first appearance, so I have no reason to doubt it. But looking at the first appearance paperwork, it says no DC for any of the charges as written. So I don't think the bond was actually set, and I'm guessing what happened is probably FDLE came back or something like that. I don't know why he hasn't had a bond set in this particular case, but he is certainly entitled to a reasonable bond.
To the state, why shouldn't it be an ROR bond for Mr. Mathias?
Given the situation, we would stipulate to an RR bond.
Okay. Mr. Mathias, so you'll be able to sign yourself out today. I'm glad that you raised all that.
Thank you very much. Thank you.
So your court date's going to be May 8th. All right, let me write that down. Your Honor, there is an information that was filed on February 28th. 2 count information. We will enter a not guilty plea waive the formal reading. Asking this to be set on the May 8th docket.
Okay. Yes, sir. Mr. Mathias, I'll see you back here May 8th.
Thank you so much, Your Honor.
Thank you, sir. That'll include the DOP. Yes, sir.
Next is McCraney. McCraney.
Oh, Mr. McCraney.
Yes, Your Honor.
Mr. McCraney, do you wish for me to appoint the public defender if you qualify financially?
Yes, sir.
Okay, the charge is trafficking in methamphetamines. How much money do you make per month?
$0.
I'm sorry?
$0, sir.
How long have you been unemployed?
For a while.
Can I give me more than that?
For more than that's 6 months. I know that for a fact.
Okay, I do appoint the public defender to represent you.
Your Honor, we do have received a 1-count information. This is a first-degree felony. Trafficking in amphetamines, 28 grams or more. We would waive the formal reading, enter a not guilty plea. Given the nature of the charge and the fact I don't expect this to be resolved by May 8th, I would ask the court for a 1-cycle continuance to the July docket.
Okay. Mr. McCraney, I'll see you back there no later than July 10th. But if your attorney wants to set a motion before that, I'll see you then.
Yes, sir. Thank you, Your Honor.
Thank you, sir.
Next is Gregory Murphy.
I have a paper. Says I go to court on the 16th. Not no second or nothing like that.
Okay, I'm just telling you, I didn't know you were in jail. Your Honor, this is Gregory Murphy. He's before this court in 23 CF 364. We do have a 3-count of information. We will waive the formal reading and a not guilty plea. Mr. Murphy's actually in custody on a failure to appear on a misdemeanor case. I would feel more comfortable with that being handled in misdemeanor court because in reviewing benchmark, there was a prior failure to appear in that case. So I'm not going to ask this court to do anything. He's not in custody. As far as I know, he's out on bond in this particular case. So I'll just encourage you, I'll talk to you, Mr. Mayor Attorney, and see if I can get him to come up and talk to you as soon as I can. Okay?
Wait a minute. I won't give you.
You're not in jail. What am I here for? I'm arrested. You're not in jail. You were arrested for jail. What am I here for? You're arrested for 3 days. This case. February 10th. You're not in custody for this case. So I can't ask for long.
You're already out. I feel I should be here now before arresting me, okay?
Your Honor, we would ask the court to leave this on the May 8th docket. I will have Mr. Murphy's, whoever his assigned attorney is, go talk to him as soon as they can. Talk to him about that.
Mr. Murphy, I'll see you no later than May 8th on this case.
What am I doing this?
That's what I'm representing.
Okay, what am I doing here for?
Mr. Murphy, let me tell you what you're doing here. You're charged with...
It makes no sense. I'm sorry, I'm sorry.
Okay.
What am I doing? Why am I here?
Let me answer
I'm trying to get something out of the way.
You're here for drug possession of a controlled substance without a prescription.
Okay, I understand that. So why would I take care of it?
Okay, so that's why you're here. Narcotic equipment and resisting an officer without bond. That's why you're in this court. You'll need to go to the misdemeanor court and talk to them about the bond that they revoked. Okay?
So I just came here just to see the paperwork?
Yep. Right, due process. Put you on notice of what you're charged with.
Okay, now I understand. So when is this?
May 8th
is May 8th.
Is when you'll see me
on this case.
Okay. And that's the misdemeanor, right?
No, this is the felony.
No,
There's a misdemeanor court. Give me a second.
Yes. Thank you, Mr.
All right, come on.
All right.
Next is Paris.
Devon Paris is next, 23 CF 432. Hello, Mr. Paris. Mr. Paris, the reason why you're here is the charge of battery by somebody that's in the jail. Do you wish for me to appoint the public defender if you qualify financially? Do you want an attorney?
For battery?
Yes, sir. Battery someone in the jail.
Your Honor, I was just discussing with Mr. Paris. He actually has a pending case right now that he's represented by private counsel down in Orlando. And so I was just inquiring, does he want to talk to that attorney about possibly taking this particular case? And he's indicated he does want to talk to that attorney about potentially taking the case.
Okay. So, sir. So, Mr. Paris, I'll enter a denial for you, and I'll set your case for May 8th. If you're going to hire a private attorney, then get them on board sooner than later so they can help you on this case. If you're not going to hire a private attorney for this case, fill out a financial affidavit at the jail, and then if you qualify, the public defender will represent you, okay? So I'll see you on May 8th. Think about those two attorneys' options.
Is this a felony charge?
Yes, sir, correct. It is. Okay, thank you, sir.
Next is Joshua Solano.
Mr. McKinney, who is this coming up?
Joshua Salerno. Mr. Salerno is here in 23 CF 300. We would acknowledge the receipt of a one-count information, waive its formal reading, and enter a plea of not guilty. And I would ask for this to be moved instead of the 5/8 court date to set this for Monday with his other case. We are trying to resolve the matter for a probation sentence, and we're trying to fine-tune the details before Monday. So I'm going to see Mr. Salerno at the jail tomorrow, and then I'd ask the court to hear this case on Monday with his other case.
Okay. Mr. Salerno, I'll see you on all of your cases, including this one, on Monday the 20th. Okay?
May I have a moment real quick?
Yes, sir.
Take this. I'll see you tomorrow.
Is this my own?
That's the copy of the charges for the doing stolen property. And then, like I said, I'm trying to get all the details on that. I'm trying to see if we can get it resolved, and I'll see you tomorrow.
Thank you.
Thank you, Your Honor.
Thank you, sir.
Cypher.
Thank you, ma'am.
Judges, Mr. Timothy Sanchez. He's here in 23 CF 405. We would acknowledge the receipt of a two-count information, waive its formal reading, and enter a plea of not guilty. This is scheduled on the May 8th court date at 9 a.m. And I'd like to try to get my hands on the discovery as quickly as possible on this case as well. It sounds like it's primarily based on surveillance video. So I'd like to be able to review that with Mr. Seifert as quickly as possible to see if we might be able to resolve the matter.
Okay. Mr. Seifert, I'll see you no later than May 8th, okay?
Yes, sir. Thank you very much.
Thank you, sir.
Terry Stone.
Next, this is Mr. Terry Stone before the court. Mr. Stone acknowledges the receipt of a two-count information, waives its formal reading, enters a plea of not guilty. The current court date is set for May 8th at 9 a.m.
Mr. Stone, I'll see you no later than May 8th.
Yes, sir, Judge Brown.
Thank you, sir.
Thank you, sir.
Next is Justin Tipton. Tipton.
Hello, Mr. Tipton.
Judge, this is Mr. Justin Tipton before the court in 23 CF 331. We would acknowledge the receipt of a three-count information, waive its formal reading, and enter a plea of not guilty. This is scheduled for the May 8th court date. Madam Clerk, I'd like all of his cases scheduled for that day. If he has at least 4 case numbers that are felony violations of probation tracking along with this, I can announce them if need be.
It's 21 CF 3157, 21 CF 3177, 22 CF 120, and 22 CF 1419.
So, Mr. Tipton, I'll see you on all of your cases on May 8th.
And Judge, as we talk, Mr. Tipton has been accepted into the Keaton program. We are negotiating with the state to see if that's going to be a resolution to his cases. So I'd ask the court leave to place him on an available docket if we reach an agreement.
Absolutely. Mr. Keaton, hopefully I'll see you before that. Mr. Tipton, I'll see you before that.
Thank you,
Next is
Judge.
Anthony Patterson. Patterson.
And this is Anthony Patterson. He's on the docket today for a motion for bond reduction. When he was arrested, a $4,000 cash or professional bond.
He on the 130 or 2?
He was noticed for 130. I don't know why. And I can pass this to later.
No, I just.
Judge, just to alleviate this, the state has stipulated to the bond motion I saw.
What do you?
The request was a signature bond, Your Honor. Convert the $4,000 cash or professional.
Then you have a $4,000 signature bond.
All right.
Okay, so you'll be able to sign out of jail.
You can guys sign out without paying.
Okay, yeah.
But I need you, when you get out, you need to call my office. All right. Your next court date is going to be. Yep. It's going to be May 8th.
May 8th.
9 o'clock. And Your Honor, I know Mr. Patterson was on the 13th docket. We filed a waiver just to save some time on Monday. I would ask the court for a continuance to the May 8th docket for Mr.
Yes, sir.
Patterson's case.
So May 8th at 9 o'clock, I'll see you back here.
Okay, yes, sir.
Thank you, Mr. Patterson.
Okay.
We've been working in the courtroom for an hour and a half, so we're going to take a 10-minute recess, and then we'll come back and hopefully finish up the afternoon. Thank you.
All rise. Court's in recess.
Great.
Congratulations, Dixie Dan Powell, for your recent induction into the National Trial Lawyers Top 100. The National Trial Lawyers Top 100 is an organization celebrating premier trial lawyers from across the country who meet stringent qualifications as civil and/or criminal defense lawyers.
At Powell, Powell & Powell, we are a family of lawyers working together as a team for our clients. For more information, visit us online today at www.powelllawfirm.com.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office on North Verdon Boulevard for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at your crestview.agent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
Hi, I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hi everybody, this is Alex again from the UPS store. Maybe I can let you in on a little secret. Did you know we're open on Sundays? Yeah, since February, probably one of the best kept secrets in Crestview, we're open on Sundays from 10 until 3 p.m.
Congratulations, Dixie Dan Powell, for your recent induction into the National Trial Lawyers Top 100. The National Trial Lawyers Top 100 is an organization celebrating premier trial lawyers from across the country who meet stringent qualifications as civil and/or criminal defense lawyers.
At Powell, Powell & Powell, we are a family of lawyers working together as a team for our clients. For more information, visit us online today at www.powelllawfirm.com.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office on North Verdon Boulevard for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestview.agent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
Hi, I'm Amanda Gaskin with Where I Press Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hi everybody, this is Alex again from the UPS store. Maybe I can let you in on a little secret. Did you know we're open on Sundays? Yeah, since February, probably one of the best kept secrets in Crestview, we're open on Sundays from 10 until 3 p.m.
Congratulations, Dixie Dan Powell, for your recent induction into the National Trial Lawyers Top 100. The National Trial Lawyers Top 100 is an organization celebrating premier trial lawyers from across the country who meet stringent qualifications as civil and/or criminal defense lawyers.
At Powell, Powell & Powell, we are a family of lawyers working together as a team for our clients. For more information, visit us online today at www.powelllawfirm.com.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office on North Verdon Boulevard for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
Sent me information on an evaluation, and so I've got the information on that. I'll ask the chief about that, or the head administrator. Ms. Dudley, I left a telephone message for her, said that she wasn't here this morning and asked her to be here at 2:30. And the third thing was on Dustin Lee's cases. Mr. Morrow is not here. There he is, right there. He's right there. Mr. Morrow, on the Dustin Lee cases, the staff, Dustin Lee Golden, that we talked about this morning.
Yes, Your Honor. I was wondering what the court would let me know.
The motions were not a nullity, so the staff attorneys are working on those. And you're exactly right, if you want to withdraw from that.
I would ask to be relieved or for the public defender to be withdrawn, Your Honor, in both of those matters.
I do grant that. It's in 20 CF 82 and 20 CF 81.
Thank you, Your Honor. We
Because they're
appreciate
not
you helping us
entitled to
clear
an
that.
appointment of an attorney at this stage in the litigation.
Correct, Your Honor. Thank you very much.
Yes, sir. Okay. Then I think next is Mark Riley. Going to be the next case.
Yes, sir. He's a carryover from the 9 o'clock docket. He's an inmate.
And then Mr. Boykin is next. Or,
After Ivan will be waiting.
Judge, Mr. Riley is before the court in 22 CF 2096 for a felony violation of probation. And this plea agreement also contemplates a misdemeanor 23 MM 182. We stipulate to this court's jurisdiction to handle the misdemeanor. The agreement that's been reached is for adjudication of guilt. In each case, 6 months Okloosa County Jail with credit for time served. That will revoke and terminate his felony probation. There would be a $100 VOP fee. There would be standard misdemeanor court costs, and then cost of defense for the felony violation of probation, and for the misdemeanor case, that would be a total of $200.
okay, thank you. Mr. Riley, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down. Mr. Riley, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
Mr. Riley, I do accept your plea. You're adjudicated guilty. You're sentenced to 6 months in the Okloosa County Jail with credit for all time served, and that's to run concurrently, run at the same time between each case and count. Your prior supervision is revoked and terminated. You need to pay the $100 cost of prosecution, $200 public defender's fee, and the court cost in the new misdemeanor case. How long do you want to pay those after you get out of jail?
120 days.
Okay, yes, sir. If you fail to pay them within 120 days, then they'll go to a civil lien or judgment.
Okay.
Thank you, sir. Next is John Boykin.
I spoke to.
This is 20 CF 546.
Yes, Your Honor. Cassie Reed on behalf of Mr. John Douglas Boykin, case number 20 CF 546. Mr. Boykin was originally set for a sentencing today. At his last court date, I believe he entered an open plea to the court. Since being retained, I've had an opportunity to speak to the prosecutor on the case, Mr. Gomez, and we have reached an agreement.
Okay.
May I announce those terms?
Please.
It's going to be a modify, reinstate, and extend supervision 1 year from his current termination date. So he will have a new termination date of March 14th, 2025. That supervision is to run concurrent to supervision imposed in Walton County case number 6622 CF 987. Sorry. Mr. Boykin shall enter and successfully complete residential inpatient treatment. He has been accepted at Project Hope in Crestview. Madam Clerk, if you could please notate the clerk's minutes to say he is eligible for release and shall be released to a Project Hope representative. Thank you. Mr. Boykin's supervision will be modified to regular probation while he is at the inpatient treatment facility, and that will automatically convert to drug offender probation once he is discharged from the inpatient treatment center. While on drug offender probation, Mr. Boykin shall abide by a curfew that is to be set by probation, and that is also modifiable for work, school, and religious purposes. He's also required to submit to random monthly UAs. All prior uncompleted terms are reinstated, and a $100 violation of probation fee is assessed. He has been previously adjudicated. May I approach?
Yes, ma'am.
Thank you. You gotta go. Okay.
Mr. Boykin, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down. Mr. Boykin, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did she answer all of your questions?
Yes, sir.
Are you satisfied with her representation?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
Mr. Boykin, before I knew that there was an agreement on that, I was doing my homework, making sure that this is the right one. And it's not. So, I do accept your plea. You're adjudicated guilty. Your current supervision is extended for an additional year so that it will terminate on March 14th of 2025. Your supervision will run concurrently with your Walton County probation. You need to enter and successfully complete the inpatient treatment at Project Hope. During that time, your supervision will be just regular probation. After you get out, it will be drug offender probation. You'll need to submit a random, well, it says monthly urinalysis. You need to pay the $100 cost of prosecution. Anything that I've missed for Mr. Boykin?
Did you mention the curfew, Your Honor?
You didn't give me times. You just said that curfew will be set by probation, and
When
it's
he
subject
gets out,
to.
he just works or something.
Okay. Probation will schedule your curfew. Okay. Thank you, sir. Good luck to you.
Yes, sir. Thank you.
And Your Honor, I did reach out to Ms. Dudley, and I will stand in for her. She apologized and did not realize her client was on the docket. So I can hang back until her client's called. Mr. Prince Robinson.
Okay. Is he in the back?
Mr. Kevin Prince Robinson.
I was thinking he was incarcerated.
He is an inmate? Okay.
So whenever you want to call Prince Robinson.
Okay. And I'll.
So we don't want them?
No, that's fine. We won't take this one. Oh, Ms. Cashman.
Good afternoon, Your Honor. Good to see you.
Good to see you again.
Your Honor, Patrice Castro on behalf of Ms. Lewis in case 21 CF 2313. I'm here today for sentencing. I reviewed the pre-sentencing investigation with my client. There were no corrections to be made. The score sheet total sentencing points 31.9. No corrections to be made to that either. We did submit character letters January 11th and January 18th. There were 29 of them. There is a statement that that Ms. Lewis would like to read.
Okay, Ms. Lewis.
I am writing you this letter with the highest of hope and prayers for the positive resolution with my case. Your Honor, my story doesn't start out positive, but I'm doing everything in my power to have an optimistic outcome. My mother was a drug addict. It put me out at 16 years old. By 17, I become pregnant with with my first child, whom is now 23 years old. Alone, and I was alone and struggled as a single mother. I did everything besides selling myself to provide for my child. By 18, I had a cocaine addiction and ended up in an abusive relationship, which led me into a lifestyle that involved extreme dysfunctional, more bad habits, and ultimately disaster in my life. One of those bad habits I obtained was shoplifting, which became another addiction for me. The addiction to cocaine took over my life, and I ended up with no moral support, a long spill as a single mother, and out of jail. I also battle with mental health issues, which during these rough times causes me to lose myself entirely mentally. My mother stepped in and Baker asked me to help me stabilize my mental issues and disorders. In 2018, while pregnant with my now 4-year-old son, I called a theft charge. I received 3 years probation, which I completed successfully. Once I had my son, I've been doing everything in my power to change my life for the better. My son is being screened for autism and doesn't do well with anyone besides me. I do not want my children or grandchildren to suffer without me being there for them due to my past, Your Honor. I am begging for you to please give great consideration on giving me probation or worse, a house arrest. I have been enrolled in CDL school and have turned out to be a productive member of society. I have done my time for the crimes I've committed, so people don't make me pay again for my past. Anything besides prison would suffice. Being that I have children and grandchildren that need me, I have stable home and great support. Now, I don't know what I wrote.
But now versus in my
past. Please give me a chance to do the right thing. Your Honor, I will respectfully pay any fines executive necessary to help rectify this situation. I am humble asking you to allow me to pursue my goals as a strong and stable mother and as a truck driver. I'm now 40 years old of age, and I'm simply asking you to grant me this opportunity to go home to my children and grandchildren to prove to society that I have truly turned over a new leaf in my life, productively and positively. Please give me a chance to do that, to do the right thing for myself and my family. Your Honor, thank you so much for your time. God bless.
Thank you.
Thank you,
Ms.
Your Honor.
Cashwell?
Your Honor, this is, in this case, she does not score out to state prison. The state attorney and myself had some extensive talks, discussions about what might be an appropriate sentence if the court is amenable to that. If the court is amenable to that, we would ask for a probationary sentence.
Okay, thank you. To the state.
Judge, Ms. Cashwell and I reached out to your office on Tuesday regarding Ms. Lewis's case. After discussions with Ms. Cashwell and reading through the PSI, we both believed that it was the most appropriate at this point to follow what the PSI said. I put a proposed sentence in the email to Your Honor if you'd like me to read it or if you have it.
No, ma'am, I've got it. Ms. Lewis, I alluded to your case unintentionally with the last defendant. I said, when I did my homework, and there was an agreement on that other one, and it wasn't that one, it was yours. When I looked through, and I've never seen, I suspect all these folks are standing up for you. So if you look over your right shoulder, is everybody here? You recognize them? It was interesting watching them stand up. It was almost orchestrated. One stood up, and another one slowly. And it was really interesting. I've never seen that before. But when I was doing my homework and looking through the pre-sentence investigation, you know, I'd go through my thoughts. And what I wrote down at the top of the note, and I feel it's very ironic that people will be sentenced to years in prison or whatever on a large But I wrote down notes that said, defendant has served up to 30 months in the Department of Corrections. And then I say PSI recommendation, question mark, meaning how in the heck can that be the recommendation of probation after all of these things? And in here, looking at your past, some of the things that I highlighted were back in 2001, shoplifting, possession, anti-theft, anti-shoplifting device, 4 months in jail, 2002 petty theft, 2003 grand theft, 2023 grand theft, state prison for 24 months. You know, there are different things that are in between this, but I focused on the theft portion because that's similar to what you're charged with here.
Yeah.
Grand theft in 2010, county jail for 270 days, shoplifting, county jail for 5 months in 2011, 2012, aggravated battery, using a deadly weapon, larceny in 2013, and then the current offense. So, you know, I was really surprised when I received the email from Ms. Davis and Ms. Cashwell to agreeing to that. Hearing what you stated today, let me find my notes that I hid from myself. Oh, you know, please give me a chance to do the right thing. You mentioned about being a truck driver. In the totality of what I've seen, I do agree with your attorneys. This may be your last chance to not go away. Your history really, really works against you. You're right in your thoughts of not getting punished for what you've done in the past and paid for. But if 30 months in prison or 24 months didn't get your attention to do things correctly, that's what the court looks at. Not to punish you from what that was, but, you know, why should a probationary sentence, how would that work? But I do agree with your attorneys. I appreciate them agreeing on a sentence. So you're adjudicated guilty. You're sentenced to 3 years probation. You'll need to submit to substance abuse evaluation and any recommended treatment. You'll need to submit to the evaluation within 30 days from today. Begin any treatment if it's recommended within 60 days from today. Submit to random urinalysis. Take the anti-shoplifting course. I do waive the cost of supervision for the first 6 months, but after that you'll have to pay the $40 per month. You'll have to pay it's a total of there was only an application fee for the PD, so that's $50, and then the $615 in court costs. Ms. Lewis, I really, really hope that what you said you take to heart and you do that in the future. You got all these folks that took their time to come here and do nothing but support you, and I certainly support you. I wish you the best. Thank you. Thank you. Thank you. Thank you, Ms. Cashwell.
Yes.
Oh, yes, I will.
Your Honor, Deputy Nash is here as well for that case, so whenever you're ready.
Yes, sir. You want to take it now?
That'd be awesome. Yeah.
Thank you, everyone. Yes, ma'am.
Thank you.
Mr. Gomez, which case is this?
They were all reading. Yeah. This is Mr. One Madrigal.
Thank you.
Yes.
19 CF 42 and 19 CF 793. Mr. Madrigal.
Good afternoon, Your Honor.
Ryan Mark with Mr. Madrigal, Your Honor. Would it be all right if Mr. Madrigal joined me at the
Certainly, please, be on the city council table.
And before we begin, I believe Mr. Gomez has stated to me that we're going to proceed on count 4 of the affidavit.
Yes, Your Honor, the portion that relates to not remaining confined to the premises that were originally approved during the control.
Okay, thank you.
At this time, the state can call Probation Officer Charles Becker to testify. And Judge, while he's approaching, the state's going to request that this court take judicial notice of the order of modification of drug offender probation that was filed in the clerk's site, or in this case, on March 31st of 2021.
No objection. No. Court takes judicial notice of that.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do. Can you please state your name for the record?
My name is Charles Becker.
Where are you employed?
I'm employed at the Fort Walton Beach Probation Parole Office.
As part of your duties, do you supervise probationers within Okloosa County?
Yes, I do.
Have you had the opportunity to supervise a probationer by the name of Juan Madrigal?
I did not actively supervise Mr. Madrigal.
What do you mean by actively supervise?
His supervision was suspended as he was incarcerated.
Okay. What are the case numbers under which you supervise Mr. Madrigal?
2019 CF 42, 2019 CF 798.
At the time of the entry of the order of modification of drug offender probation, do you by chance have that in front of you?
I do.
At the time that that was entered into, was it you or another officer that was meeting with Mr. Madrigal at that time?
That was another officer.
Okay. Is it normal in your office for a probationer to be supervised by multiple probation officers during the course of their probation?
Yes, sir.
Were there any notes left by any previous probation officers that supervised Mr. Madrigal that stated that Mr. Madrigal did not understand the terms and conditions of his probation?
No, sir.
Okay. Judge, if I may approach the witness.
You'll show tomorrow.
So I'm handing what the state has marked as the State's Exhibit 1, which is the order of modification of drug offender probation. There are what appears to be 3 signatures down at the bottom. Is Mr. Juan Madrigal's signature one of those?
Yes, sir.
Is there another space for a probation officer?
Yes, sir.
Okay. And then the last one, is that signed by the Honorable William F. Stone?
Yes, sir.
Okay. During the course of your business, or when you guys are speaking with probationers, is it commonplace to review an order of probation and then have a defendant sign it once that order of probation is explained to them?
Yes, sir. We would need to instruct them and make sure that they understand the conditions of probation that they are signing. Upon signing it, they have acknowledged the terms of their probation.
So there is no situation where a probation officer would make a defendant sign an order of probation or an order of modification of probation if they did not understand the terms of that order?
No, sir. We ask them many times throughout the course of their instruction, do you understand? These are the conditions of your supervision.
As a term and condition of Mr. Madrigal's supervision, was Mr. Madrigal required to remain confined to an approved residence?
Yes, sir.
Okay. If you will, just for the court so that we have it on the record, can you read Section B from the Order of Modification of Drug Offender Probation?
You will remain confined to your approved residence except for 1/2 hour before and after your approved employment, public service work, or any other special activities approved by your community control officer.
Did Mr. Madrigal have any approved employment, public service work, or any other special activities which would permit him to be outside of his residence on or about February 19th of 2022?
No, sir.
As a term and condition of this supervision, is Mr. Madrigal required to abide by a curfew?
Yes, sir.
Does that curfew require Mr. Madrigal to remain at his residence between 10 p.m. and 6 a.m.?
Yes, sir.
Did you or any other officer provide Mr. Madrigal permission to leave his approved residence outside of those hours on February 19th or February 20th?
I can only speak for myself, sir, and that is no.
Was there a violation report filed in this matter?
Yes, sir.
Is it your request that this court revoke and terminate Mr. Madrigal's supervision based upon the allegations in that violation report?
Yes, sir.
I have no further questions, John.
Thank you. Mr. Morrow?
Good afternoon, sir.
Good afternoon.
And again, to be clear, you were not the officer that initially instructed Mr. Madrigal, correct?
Yes, sir.
In fact, you didn't really supervise him at all when he was actively on supervision. You didn't come into the case until after he was picked up on the violation, correct?
Yes, sir.
Okay. And before court, we were talking about some of the notes in the file, and those notes, that wouldn't necessarily reflect every single conversation that the probation officer had with Mr. Madrigal, would it?
No, sir, not every single conversation.
And in fact, you yourself probably never had a conversation with Mr. Madrigal, correct?
No, sir.
All right. Those are my questions, Ron. Thank you.
Can you redirect?
No, I would like to admit the state's exhibit 1 that I
Any objection?
No.
State's Exhibit 1 is admitted.
I have no further questions, Your Officer.
Thank you. May Mr. Officer Becker be released?
Yes. Thank you.
Mr. Morrow, you okay with Officer Becker being released?
Yes, Your Honor.
Thank you, sir.
Thank you very much, sir.
Your Honor, at this time, if we can call Deputy Nash, that's fine.
Thank you.
Can you raise your hand? Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? I do.
All right. Can you please state your name for the record?
David A. Nash,
And where are you employed?
Okloosa County Sheriff's Office.
And what was your position on the date of February 20th of 2022?
I was a patrol deputy in Alpha Central.
Okay. Did you report to the location of 212 Racetrack Road on that date?
I did. Yes, sir.
Why did you report to that location?
There was a call of a disturbance of a possible battery, so I was the second deputy on scene to that location.
When you got there, what did you observe?
I observed I had another deputy there. Deputy Langer was talking with the victim, Ms. Hernandez, and she had injuries to her head and face. EMS was on scene attending to her injuries. I took pictures of her injuries.
Did you speak with the defendant in this matter, Mr. Juan Madrigal?
Not at the location. He wasn't at that scene. We actually were told by her that he could possibly be at his wife's house.
Okay.
So we left
there. Where was that at?
And if I referred to my...
Yes.
Yes. It was at 995 Denton Boulevard, apartment F2.
Did Mr. Madrigal explain why he was there?
Yes, he when he asked what happened, he said that he jumped out of the vehicle because he thought he was poisoned by Ms. Hernandez, and that he ran to his wife's house.
Did he state why he was in the vehicle?
My best recollection of what he said was he had Ms. Hernandez drive into his wife's house to get something, and they were driving back, I believe, to the Circle K at the time.
So Mr. Madrigal actually stated that he was riding around with the victim?
That is correct.
If I may approach, Judge.
If you'll show Mr. Morrow first.
This is the... Do you recognize what I have marked as State's Exhibit number 2?
Yes, I do.
What is State's Exhibit number 2?
I'm sorry?
What is State's Exhibit number 2?
What is it state? I'm sorry, it's my body
Yeah,
cam footage.
it's your body cam. Oh,
Yeah.
I'm sorry, say that again.
It's my body cam footage.
Okay. Have you viewed what's on that
Yes, I have.
tape? Is your signature on that
Yes, it is.
CD? Is that video a true and accurate depiction of the events that took place on the night of February 19th of
Yes, it is.
2022? Okay. Does the video appear to be edited or altered in any way?
Not to my knowledge, no.
The state's going to play this video.
First, you want to seek to admit it into evidence?
Yes, if we can amend it, Mr. Honor.
Mr. Morrow?
May we approach Sean?
Yes, sir. Sir. So, Mr. Gomez, do you know what numbers from when to when are you actually going to approach?
I have to know the
Thank you.
It is going to be from approximately 1550 to 1920.
1550 to 1920? Okay. And no objection to that being admitted?
No objection. Thank you.
So that portion of State's Exhibit 2 is admitted into evidence.
It's 1543, okay. It's 1543, okay. Okay. Your Honor, I think we have some audio issues in terms of connecting, so I'm gonna have to like put this microphone kind of right close. And there's no audio anywhere. What do you mean? Yeah. We seem to be having some audio trouble. Wait.
told you he's schizophrenic, so I think he says a lot of reading done for him. You're crazy, man. Come on. I'm crazy. I'm trying to
All right, listen to me.
I don't feel this, sir.
Okay, you said listen, okay? You have the right to remain silent.
For what?
Anything you say can be whether you're demeaned in court of law.
Sir,
You have the right to sit in the shame.
I can't even, my heart's racing. She poisoned me. You can test the goddamn car. It's all over it.
Okay. I know you didn't want to talk to you though. Is it your right to help you, okay? So you have to remain silent. Anything you say can be used against you in court of law. You have the right to speak to an attorney for the right before questioning. You can have another present during questions. If you cannot afford an attorney, then you will be fully appointed to present you free of charge before questioning is desired. If you decide to answer any questions, or make any statements without having an attorney present, you will still have the absolute right to stop answering questions or make a statement at any time until you speak to an attorney or have him or present during further questioning. Do you understand your rights? Just speaking yes or no? You do? Okay.
Can I ask what this is about?
So, what happened next?
My wife kicked me out 2 days ago.
Is your wife here?
Yes, sir.
Okay.
We've been separated for 3 years. And, so I was forced to go move to a motel, and the community patrol officer knows. Today she was just driving around the city.
Who was driving around?
Full Arredondo.
Hernandez?
Yeah, something like that. You never know.
Okay, so she put you go around driving around with her?
And the daughter.
Oh, yeah, right?
Yes, sir.
So 30.
Yes. And I came back from my wallet. I couldn't find it. We left. And I don't know, she got me a bottle of water. And I drank about, half of it. And she looked at me and said, I'm feeling sweat. My heart's beating hard.
Right.
Can you test the car? I mean, ask to talk to you. Talk to the baby.
Who's the baby? How old is her daughter? 18, so she's not quite a baby, right? She's 18, 19? Yeah. Now I have to take a look at this side of it? You can probably take a look. Can I see your hands at all? Okay, so you were driving out with her, and then how did you get, when you left her, what happened? Where did you leave her at?
Going down past the boys, the boy and girls club, I jumped out.
You jumped out of the car?
All right, Judge, that's the portions of it. But, Deputy Nash, I just wanted to ask before you got off the stand, hearing your body camera video again, did the defendant state multiple times that he was riding around with the victim in this case?
That is correct.
And that he actually came back to his residence and then left again?
That is correct.
Okay. I have no further questions, Your Honor.
Mr. Martin Cross?
Yes, Your Honor, I have one. Good afternoon, Deputy. Did Mr. Madrigal ever tell you where he was coming from
Well,
before he had arrived at Denton? Was that clear to you?
He was staying in a hotel room, he said.
Okay, a hotel room?
Yeah.
All right. And the place that you arrested him at, that was 995 Denton Boulevard, apartment F2, Fort Walton Beach, correct?
That is correct.
All right. Those are my questions, Your Honor. Thank you.
Thank you. Thank you, Deputy Nash. Thank you, sir, for your release.
Judge, I'll get the back.
Or, since I just said those portions were removed, Madam Clerk, is that okay? Or do you want them to replace it with one that only has that?
I think for safety, I'd rather make sure that we had only the necessary stuff.
Okay. So you'll need to give that to Madam Clerk and then they'll replace it. Any other evidence from the state?
No, Your Honor.
Okay. Yes, sir, Mr. Morrow?
They have one from my client, Your Honor.
Yes, sir. argument from the state?
Your Honor, I think the video and the testimony from Officer Becker as well as Officer Nash kind of speak for themselves. The issue here that we had was that he had an approved residence that he was confined to. I do know that there was some changes between his wife's house and the hotel, but as he clearly testified, he was riding around with the victim. The reason why we place people on community control is so we can make sure that we have an idea of where they are at all times to eliminate and reduce any of these potential issues, like what happened in the underlying offense in this case. And so, given that, post Miranda on the deputy's body cam, he admits that he was riding around unapproved. The probation officer testified that he did not know or give him permission, that no other probation officer knew or gave him permission to be able to ride around and go from place to place with the victim in this case. For those reasons, I think it's clear that the violation of community control did occur and that this defendant should be found guilty of the violation.
Thank you. Yes, sir, Mr. Mark.
Yes, Your Honor. It's the position of the defense that the state has not carried the burden of preponderance of the evidence as to a willful and substantial violation of probation in this case. What we have is Mr. Madrigal being arrested at his approved residence, having ran there, essentially. We don't have the benefit of Mr. Doobie, who was actually Mr. Madrigal's supervising officer, who was initially given instructions and had all the interaction with Mr. Madrigal. We have here Mr. Becker. We appreciate him being here in his testimony, but he can't speak to every single conversation that was had between Mr. Madrigal and Mr. Doobie. It's the position of the defense that Mr. Madrigal was doing his best to comply. He had arrived back at the residence by the time that law enforcement arrived there. He was trying to get there. He was staying at a hotel, is my understanding, because there had become some issues at his approved residence. And his assertion to me that he had been given permission by Mr. Doobie to be at that hotel, and he was in transit from the hotel.
Objection, Your Honor.
Correct. That was
Yes,
Ms.
sir.
Smith.
The objection is sustained.
Understood, Your Honor. And so we're asking the court to recognize all of those things and find that this is not a willful and substantial violation of probation. It's unfortunate that we have prior violations and also he's qualified as an offender of special concern. Otherwise, we'd be talking about mandatory modification for 90 days in county jail. And I'd ask the court to consider all that in its ruling.
Thank you, Mr. Morrow. Mr. Madrigal.
Yes, sir.
I can only play the hand that I'm dealt. I can only deal with the evidence that comes in. The objection that was raised by the state was your attorney was starting to say things that weren't admitted into evidence. I can only go with statements from the probation officers, what came into evidence, the video, and based on that, the court does find that there was a willful and substantial violation of your supervision. I do look at, the weight of the evidence as far as the officer, but that's all I've got. Right. So I don't have anything to contradict that. So as far as sentencing for Mr. Madrigal, how do you want to do that?
Your Honor, there is a very lengthy suspended sentence, so I think it would be appropriate to set sentencing off, give us time to get some sort of investigative report or PSI.
Do you request a PSI?
I don't know that I'm asking for a PSI, Your Honor, but I would ask us for a set sentencing to see if it's necessary in preparing a mitigation, and I may be able to provide.
Okay, so how am I going to know if your client waives the PSI? You file something by Monday?
I have a moment, Your Honor, because I think I may be able to answer. I don't believe he'll be entitled to a PSI, Your Honor, so I don't know if that would be an issue, but I would still like some time.
Okay, so are you waiving the PSI? You're going to tell me by Monday?
I'll waive it, but what I'm saying is I don't think he's entitled to one in this case. Okay. So I don't think I need to waive it, but I will waive it for sure.
Okay. How far out do you want to set the sentence?
I would ask for a month. I know the court has 4/10. I don't know if the court has a late April date.
April 13th, April 17th, April 20th.
The 20th would be great.
Okay. April 20th at 2:30.
Thank you, Your Honor.
Mr. Madrigal, I'll see you then.
Thank you.
Thank you, sir. Next I had on the list was Jason Powell, or Poe.
We got Prince Robinson coming for Cassie, did you say?
I'm covering for Ms. Dudley. That's
From the AM
Oh, good. Yes, ma'am, that should be quick on it.
Yeah.
Ms. Robinson.
Your Honor, I believe that's all I have. May I be excused?
Yes, sir. Thank you. So this is Kevon Prince Robinson, 21 CF 2602. Hello, Mr. Robinson.
Yes, Your Honor. Cassie Reed, standing in for Ms. Dudley. This is Mr. Prince Robinson's VOP case, 21 CF 2602. Mr. Prince Robinson also has a new law violation that is on the May 8th pretrial docket. I believe that is 23 CF 260. And Ms. Dudley is just asking to enter a denial and track this VOP case with the new law violation.
Okay. Mr. Prince Robinson, do you agree to that? Your two cases running together? Okay, then I'll see you on May 8th on both of your cases. Okay. Thank you, sir. Thank you, Ms. Reed.
Thank you, Judge. That concludes my business. May I be excused?
Thank you.
Oh, Ms. Dudley did want me to apologize to the court. She had not got your email, even she checked, and she had not received
email,
it.
I called it your phone and left a voice.
Oh, okay. I said email, so that's my
I thought
bad.
that'd be quicker than trying to email.
Yes, okay, so I was incorrect when I relayed that to her, but she did apologize.
Thank you.
Next is Jason Poe.
Okay, thank you. Mr. Darwin.
Good afternoon, Your Honor. Your Honor, Mr. Poe is present, 22 CF 2804. He's before the court on a motion to reinstate bond.
Yes, sir.
Judge, he's been incarcerated since January 18th. He owns his own business doing remodeling work. He employs his son. He's lived in the area for 39 years. He resides in Fort Walton Beach. He's a single father. He has 3 kids, ages 18, 12, 9. Judge, the bond was revoked for a new law violation in 23 CT 146 that has been resolved. We would ask the court to reinstate the bond in 22 CF 2804, Judge.
Okay, thank you. To the state?
The state would object to setting a bond in this case. These charges are concerned of fleeing and attempting to elude, driving a license suspended, and giving false names to Rios. While he was out on bond in this case, he then continued to drive, and that's where the new law stems from. Given that it doesn't seem as though he's going to stop driving, the state would request that we keep a no bond in this case as he has continued to commit new law violations when out on bond.
So the CT case was driving without a license?
Yes, sure.
Mr. Darwin, why shouldn't that get, no pun intended, why shouldn't that get a lot of traction with the court?
Judge, we resolved that case this week. He was given credit for time served. He does have a lot of work that he has been missing over the last 3 months, 4 months. Like I stated, he employs his son. He has another employee as well. They are struggling to make ends meet without their supervisor being there. Judge, in the instant case, we do take issue with the stop itself. We believe there may be a motion to suppress on that. I still need discovery in the case before I can file that motion, but we would ask the court to reinstate his bond on this case.
Okay, what was his bond? What were the
I
charges?
believe it was a total of $7,500. Is that right?
Any other conditions on it?
I don't believe so, Judge. I don't know if the state can advise on that.
I'm going to try to pull it up here.
And so, Mr. Poe has 2 incidences, alleged incidences. One was proven in the CT case, and then the other one is this one of driving while license suspended or revoked.
Correct, Your Honor.
Okay. Mr. Poe, we're trying to look at things kind of in a macro sense. If you were just charged with that, driving without a license, second or subsequent offense, would the court not give you a bond? I understand the state's argument is, but he was under the bond conditions at the time that he drove the second time.
I'm having a hard time finding, Judge.
Okay. Weren't any accidents or anything like that that were alleged against Mr. Poe?
No, Your Honor.
Mr. Poe, your motion to set bond is granted. The bond is reinstated. I don't think I have to say no driving because you don't have a valid driver's license. But that is a condition of the bond. You can't commit any new law violations. If you drive again, then you're not going to get out.
Yes, sir.
Okay. So I do grant your motion for bond.
Thank you, Your Honor.
To set bond and reinstate that.
Thank you.
So you're welcome. I'll see Mr. Poe on May 8th. Is that
Your
accurate?
Honor. Yes, and I do have a proposed order. I'll show it to the state, Your Honor.
Mr. Poe, I'll see you on May 8th at 9 o'clock. If the state offers you something that you want to accept before that, if you want to avoid 300 or 400 defendants, you can ask Mr. Garham to set a hearing before that date.
Yes, sir.
Thank you, sir.
Thank you, Your Honor.
Who's next, Your Honor?
You had next, Lewis,
We already heard it.
Joseph Rogers.
Rogers?
Allison, did you take Mr. Switek's case into consideration?
No, who's this?
Mr. Switek, if you'll unmute your mic, who is your client?
Mr. Rogers.
Hello, Mr. Switek. Ma'am? Setterberg. Mr. Switek, how long is your case going to take? Mr. Setterberg.
I'm sorry, Judge, are you talking to me?
Yes, sir, I am.
Jacob Rush, we're here for a status conference with Mr. Director.
Yes, that one is the fast one. I have that on the
Okay. You had Rogers down next, but you want to take Mr.
I can take that.
Okay, Rush?
And Mr. Rush is present with his father.
Good, thank you.
Is the person back, Your Honor?
Yes, sir. Mr. Rush, if you'll come to the lectern. And you did have that on there. I don't know why. Mr. Rush's case is 21 CF 535, and Mr. Switek, so when I was doing my homework, I looked at the exam that was done on 9/26/22 and the evaluation that was done on February 14th of this year. So where are we on Mr. Rush's case?
Your Honor, there was a report by Dr. Zeman, which was the most recent, report by Dr. McDonald, report by Dr. Harper, report by Dr. Heather Holmes, as well as the report of the examining committee in the guardianship case. I believe Ms. Brickman wants to set this for a hearing to take testimony.
Okay, Ms. Bergman?
That's correct, Judge. Due to the number of evaluations and the conflicting opinions, we'd asked to set this off so we can bring in some of the doctors to testify as to their evaluations and how they evaluated the defendant.
So if we could set him for a miscellaneous day with perhaps a longer chunk of hearing time, like perhaps April 20th, how does that look, Madam Clerk?
Okay, April 20th at 2:30. When I hear, Mr. Rush, when I hear about all the doctors that you've talked to, and I think about the guardianship case, just make sure everybody's singing from the same sheet of music as far as what the court has to find in this case versus what it has to find in a guardianship case. If I have somebody telling me apple, 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 and the other one's telling me orange, orange, and I'm supposed to find orange, I don't know what to do with the apples. So just let me know, make sure that the experts know what's relevant to the court.
Yes, Your Honor.
So, Mr. Rush,
Yes,
I'll see you back here on April 20th at 2:30, okay?
thank you, Your Honor.
Thank you so much for bringing Mr. Rush again.
Yes, sir.
Yes, sir, and thank you for dressing up.
Yeah, bless you.
You too, thank you, sir.
Thank you, Your Honor.
Thank you, Mr. Schweitek. Joseph Rogers is next.
Correct, Your Honor. David Rare for Mr. Rogers. We're here in 22 CF 2515 on previously filed motion to suppress. Administratively, there is an officer here to testify, but in speaking to the state, he testified previously at the DMV hearing related to the same issues that we were asking the court to rule upon. We filed a copy of the transcript of that hearing in the court record. I think we discussed dispensing with the officer testifying and letting the court rely on the sworn testimony previously taken. I have a courtesy copy if I can approach the court.
Yes, sir, thank you. Thank you, sir. Okay, so where is Mr. Rogers on the clock? He was added and I don't have the
He's
latest.
under Mr. Lupella's name.
Got it. No question. Thank you. Okay, so I'm up to speed. I obviously haven't read the transcript, but what do y'all wish to do?
How we discussed proceeding, Judge, is the motion is very short. There are certain rules and procedures that apply to making a breath test, obtaining a case admissible in evidence in later proceeding of trial. We cited that in the motion and support the case.
I did read through that. I made highlights of your motion.
Correct. I think how we're going to proceed today, I understand the court hadn't had time to skim through that. The court has other cases today. There's going to be some brief argument from the defense, brief argument from the state. Allow the court time to review that and render ruling quick time.
Okay, good. Yes, sir.
I'll try to be brief.
If you want to turn that microphone towards you. If you want to sit down, you can, Mr. Ray.
I appreciate that, Judge.
Thank you.
First, for the court's benefit, not all the transcript hearing is relevant to what we're asking the court to rule on. Page 19 of the transcript is where the issues pertinent to the instant motion would begin, and I think through the rest of the transcript is what the court would need to review for that. Essentially, Judge, without any further testimony, video, or other evidence, the uncontested sworn testimony of Officer Carl Darius Hanford of the Walton Beach Police Department, who was the arresting officer in this DUI case and also the breath testing officer in this case for Mr. Rogers. The uncontested sworn testimony is that he does not ever remember doing a mouth inspection as part of the 20-minute observation period. Leading up to the time, he did collect 2 breath samples from Mr. Rogers. He was very candid, I will say, at the DMV hearing when kind of asked point blank about that, as the transcript will reveal. He indicated there is no video or other evidence that would show substantial compliance was actually obtained in this case regarding the mouth inspection that's typically required as part of that 20-minute observation period under the administrative rules to make a breath sample valid, reliable, and then later admissible into evidence in the later proceeding. The hearing officer in the case, Officer Hogan, ultimately agreed there was not a reliable sample. There was no proof that he could determine substantial compliance was made. He overturned the license suspension based on the breath level in this case. I would note under statute, this court is not bound by what the hearing officer determines. I attach that just for reference and for the court's benefit. However, the statute does say this court can do what it feels is appropriate. Their agency can do what they feel is appropriate. But it presents the exact same testimony issues. We're asking the court to rule on the motion to suppress.
Okay, so let me ask you a question. So what do I have to find versus what did the administrative hearing officer have to say?
It's the same issue. Was there substantial compliance by the officer with the administrative rules that are necessary for the breath level to be considered reliable and admissible into evidence? When I note the statute says this court is not bound by that, it is written in such a way that this court is not obligated to rubber stamp what DMV decided. In a similar fashion, in this case, were it to be dismissed entirely today, DMV is not required to rubber stamp what this court has done or the state has done. They can still proceed under their own administrative rules. But for what it's worth, that is included, Judge.
Substantial reliance
substantial compliance.
Compliance with the administrative rule? With what? Substantial compliance with what?
It's Rule 11D-8.
I have a copy of it, if Your Honor would like it.
That'd be great. Problem because of the separation of powers is why one can't bind the other. One's an executive branch, and the other's the judicial branch. Okay, thank you. Yes, ma'am. Steve.
Judge, essentially what the defense is asking Your Honor to do is breathe into the rule that is written that requires a 20-minute observation period, to also add in that means that the breath testing operator has to physically inspect the mouth of the person that is taking the breath sample. So that's not what the rule says. The rule says that there has to be a 20-minute observation period. You can see in the transcript that 20 minutes was done according to Officer Hansford's testimony. He said that he was in the room the entire time. There was another officer, Officer Sterling, that came in and out during that time period, but he was in there the whole time to make sure that everything was okay. So I think some of the problem may come at some of the cases that are being relied on by the defense are a little bit outdated. Like Donaldson, it's been superseded by statute. That's why this rule is different. I think we're discussing in the motion that they provided some old rules that are no longer really applicable. So that's why State v. Irizarro and the new rule has changed things. So it's not exactly what it was when Donaldson was decided. Now, what we do also need to take into account that if Your Honor believes that there was a rule violation, that doesn't necessarily mean that the breath test is out. What it then does is requires the state to lay the necessary traditional scientific predicate for the breath test under the Bender standard. So that's where it just takes out a step of the reliability of the results of the test if the rule was substantially complied with, which is the standard that we're looking at here. So from the state's perspective, we believe that as the rule is written, that there had to be a 20-minute observation period that was done, that was complied with according to Officer Hansford's testimony. And so we believe that at this point, the defense's motion should be denied.
Mr. Everett, your motion, you get the last word.
The purpose of the rule, as stated in the rule, is to make sure there are no contaminants in the mouth, there's no regurgitation, putting anything in the mouth, including water, as the case law bears out. It is standard procedure with all law enforcement agencies, including for Walton Beach PD, that they conduct a mouth inspection as part of that 20-minute observation period to ensure that compliance is had. We don't have to speculate about that. That is in the transcript. But he also testified usually he would do himself a mouth inspection as part of the 20-minute observation period, and he testified he did not recall doing that here in Mr. Rogers' case, in this case. So we rely on the rule, the case law, and what the actual transcript reflects that he testified to back on November 1st, 2022.
Mr. Rogers, everything in me wants to just stop and read through the transcript and read this and make that decision this moment. We've got other folks, so I'm not going to do that. I'll take it under advisement. I will read it tonight, and I'll let the attorneys know tomorrow. I'll email them and let them know my ruling, okay?
Yes, sir.
Thank you, sir.
All right, thank you, Your Honor.
Judge, that's all I have for the afternoon.
Yes, ma'am. Thanks, Ms. Davis. Thanks for a long week. Mr. Ritter, hold on one second. So this is set for...
I think we're set for Monday for status, Judge, if I recall.
Okay. Are you going to be here anyway? Do you have any other clients? I was going to waive your clients.
I think we've got to have a couple cases set, Judge. Could we waive his appearance? I'll still appear just for the status conference and have that.
Okay. Are you going to be here anyway? Or?
Yes, I'll be here, Judge.
Yes, sir. Then I'll waive Mr. Rogers' appearance. Mr. Rogers, you can be here if you want to, but you don't have to be on Monday.
Okay.
Thank you, sir.
Thank you, Judge.
Sir, I'll see you then. Time to clear is next. Mr. Shaw.
Good afternoon, Judge. How are you?
Hey, so good. How are you?
Hello, sir. How are you? Good afternoon.
Okay, so I read through the state's March 14th letter and the attachments to that.
And Your Honor, I'm sorry, the court has the benefit of the score sheet also with that? Does the court need an additional copy of that?
I do have the score sheet. Yes, ma'am. Thank you. And then I have the, are we here for sentencing?
We are, Judge.
Because I had the motion to suppress where I had previously ruled on that. Y'all didn't provide me anything in writing, did you?
I didn't, Judge.
You want the state to start, Mr. Patel, or you want to start?
I think I should probably start since I've got something to prove. Jay Patel and Tim Shaw on behalf of Tyler Clear, 19 CF 3074, were before the court on sentencing, in which Mr. Clear has pled straight up to the information as charged. We have a couple matters of housekeeping. While the record specifically, well, it's documented. I don't know which item number, but we just want to reaffirm Mr. Clear's reservation of his right to appeal, and that for the motion to suppress, as the state has agreed that that motion was dispositive. Outside of that, Judge, we're looking to, we understand the state's position and what they're looking for, and we're looking for a downward departure. We're asking the court to look at and ultimately find that the court can and should depart. And the two downward departures we're looking for, the first one is the one related to a mental disorder, the need for specialized treatment, and that the defendant is amenable to treatment. The second downward departure is that the offense was committed in an unsophisticated manner. It was an isolated incident, and the defendant shows remorse. In order for us to present evidence related to the first downward departure, the defense calls Dr. Randy McDonald. By stipulation, we agree that she is an expert in her field, and her report has been provided by Mr. Clear's previous counsel, Mr. Klein's, on the docket.
Okay.
Excuse me, being asked to be admitted into evidence because
I'm fine with putting it in evidence.
I'm just asking.
Yeah. So, Judge, I'd ask, and the state stipulates to move Dr. McDonald's report into evidence.
When was that filed? Because I haven't read through that. Nobody flagged me to say, look at that.
I need to pull a benchmark real quick, Judge.
Do you swear or affirm the testimony is the truth, the whole truth, and nothing but the truth?
No, I don't know what the docket number is. Oh, no, I got that one. I just did Judge, we believe the date is January 15th, 2021.
Moved by Mr. Kleinstein.
Okay, and so the state stipulates to that being admitted?
Yes, Your Honor.
That report is admitted into.
And Judge, it's listed as defendant's response to demand for reciprocal discovery.
Do you know the document?
I'm pulling that up right now,
Or just
Judge.
what date it was filed with the clerk? Do you have that?
I believe that date was January 21st, 2021.
It looks like docket number 185. Let me just double check that though, Judge. It is docket number 185.
Okay, so that is defense. Okay.
Good afternoon. Please state your name for the record.
My name is Dr. Randy McDonald.
And tell me how you got involved in this case.
I was retained initially by Scott Kleins of the Office of the Public Defender to complete, it's often called a psychosexual evaluation, but I refer to them as a risk assessment.
And did you have the opportunity to meet with Tyler Ray Clear?
I did. We met across multiple sessions.
Okay. Can you tell the court how many times you had an opportunity to meet with him?
So I met with him 4 times. Clinical interviews totaled about 6 hours, and then we did some administration of tests and sexual history questionnaire. That was another, I think, 3.5 hours.
And can you tell me what history you reviewed during your analysis?
Well, we requested records from prior treatment providers. I was able to gather some documentation from Pamela Wright. She had done a brief an assessment of attention deficit hyperactivity disorder, a very brief assessment. I also received a treatment summary from a counselor he had seen, Ann Ambrugio, and I also had treatment records from Fort Walton Beach Medical Center where he had an admission there.
Did it appear to you, because you talked about kind of 3 different instances, so the Fort Walton Beach treatment, that was related to a Baker Act, is that right?
Yes, sir.
Okay, so that was involuntary. The previous 2, did you discover that those were voluntary?
They were voluntary, and he actually saw another therapist at a different time. To look for the name, but I did not receive records from that person. So he had been in treatment with two different providers for counseling. He had seen one person for a brief assessment upon referral of one of his counselors, and then we had the involuntary admission at the hospital.
And during your interactions with Mr. Clear, were they consistent with the paperwork that you saw as to the previous instances of therapy?
Yes, I would say so. And I received a treatment summary, so I didn't have detailed notes from the one provider, Ms. Ambrugio. But it seemed that his presentation to me was generally consistent with what she had seen as well.
When you met with Mr. Clear at the Okaloosa County Jail, was he under the was he taking prescribed medication?
He was. He had been prescribed Prozac during his involuntary admission to the hospital, and that was continued at the jail.
Okay. Did you understand or whether or not he was prescribed any medication before the prescription for Prozac?
I don't think he had taken any before. He had just done counseling. Now, following the evaluation for ADHD, his primary care physician had reportedly prescribed some medications, but he had not had a chance to start taking them prior to his arrest.
Okay. And during the time he was at the Okloosa County Jail, did you understand that he was faithfully taking his medication?
Yes.
By his own will?
Yes.
Okay. Maybe we'll start it this way. Did you get an ultimate diagnosis for Mr. Clear?
Mr. McDonald, I just need to understand. Dr. McDonald, what time period are you talking about? When they talk about a report in 2021, are we talking about that? Or are we talking about you did something subsequent to that?
I met with Mr. Clear between July of 2020 and November of 2020, and then I submitted my report.
Thank you.
And the instances that I was just talking about for voluntary treatment, that occurred before then?
Yes, I'm sorry. That was in 2019. We first sought treatment in 2015. That was with Miss Ann Ambrosio of Stepping Stones. Met with her a few months that year, then went back into session December of 2016. He was absent from therapy until July 2017, when he resumed again. The evaluation for ADHD was completed in September 2019. He had done about 5 months worth of treatment with Sandra Hines in Georgia in 2019, but I did not get any documentation from her to give you more specific dates.
Now, ultimately, did you get a diagnosis that was different than what he'd been previously diagnosed with?
So pretty consistently, there were indicators of chronic problems with depression and anxiety. In talking with him and through the testing that I did with him, there were indications of bouts of what we call hypomania. So it's like mania, but not as intense. So my opinion was that he likely suffers from bipolar II disorder.
Okay. With that disorder, is there a need for a specialized treatment?
Yes, most people take medications to help manage or diminish mood fluctuations. Depending on severity of symptoms, they may also require medications to manage insomnia. Counseling is also generally recommended for folks who have that condition or any mood disorder, really, to help them develop non-medication based coping strategies and learn to live without aggravating factors for their condition.
And as it relates to, can you give the court some comfort level as it relates to his diagnosis and the discussions you've had with him regarding his charges, and kind of make some sense of that?
So, in talking with Mr. Clear about the offenses, there seemed to be a pattern of increased pornography viewing when the mood was in a bad way, so either depressed or in that more hypomanic phase. So what he consistently described to me was that during periods of distress, and it might not just be mood disturbance, but there were usually psychosocial stressors that were present as well, so relationship problems, transitioning from the military, dissatisfaction at work, things like that. Usually these things would sort of pile on together, and he would rely on use of pornography as a way to relieve his distress or his tension that he was feeling because of these other things that were happening. So he would go on what he would call benders, and he would just spend hours and hours looking at pornography and masturbating to pornography. And he would kind of progressively move up, if we were to use the term hierarchy, of the things that he would look at. So he would start with what most people would consider normal pornography, and then it might move on to something that is a bit atypical. Some people might enjoy looking at that, but he would kind of go up through this hierarchy, and at the very top of that would be child pornography, and he didn't start there, but would, before his arrest, would end up there. So there was this increasing satiation that would come with viewing one level of material, so he would seek something novel, no taboo. Once that reached a level of satiation, to go to the next one. And the more of these evaluations I do, the more things I read, I'm finding that this is a pretty common pattern amongst people who are spending a lot of time looking at pornography. Recently we've been reading about pornography addiction and that kind of stuff, and that's sort of this pattern that develops with folks that are finding themselves addicted to pornography, for lack of better words.
Is it the content of the pornography itself the driving factor, or is it the physiological response to the human looking at the pornography a driving factor?
Probably.
Does that make sense?
Yeah, probably both. I mean, what's happening is that when we're looking at something like that, it's stimulating, and not just sexually, but visually. We're visual beings. And so when we're looking at something like that, we have a physiological response to it. And as we kind of get used to something, we go to the next level, and that next level may be something that is really anxiety provoking, but it's perceived as stimulating, sexually stimulating, because our adrenaline is up and all those kind of things. So the content is stimulating, whether just visually, sexually, whatever it may be. You may have to restate your question.
No, that's, and what I want to get with that is there a way, in Mr. Clear's case, based upon your analysis, of a clear treatment plan, and tell the court what that treatment plan is to get him on the right path, instead of using pornography as a coping mechanism?
So with Mr. Clear, it certainly starts with management of mood symptoms and reduction of psychosocial stressors. So remaining compliant with medications. When I had spoken with him, it's been a couple years now, but the medication he was on was helpful, but maybe not the best thing for him to be on. He wasn't getting full relief. He was still having some mild up and down. So probably needs to undergo a psychiatric evaluation to reevaluate what medications may be most helpful. Certainly individual counseling to address some of the dynamic risk factors that identify in the report. So he would have bouts of substance abuse, he would abuse alcohol, so that certainly needs to be addressed. Relationship difficulties, he described a lot of his relationships as sort of crashing and burning, so dealing with those sort of interpersonal challenges that come up in relationships. There were a lot of issues with low self-esteem and lack of assertiveness, So just a lot of kind of general psychological type things to address in therapy. And then certainly sex offender treatment. And here locally we have one program. It's in Pensacola at Cordova Counseling Center, well-established program that is at least a year in duration. We work with probation directly. It's group setting unless the person has specific needs that can only be met individually, and then they can provide the service individually. But I think those three things, individual counseling, sex offender treatment therapy, and medications, that needs to be the plan to help him address the issues that got him to where we are today.
Do you believe objectively that he's amenable to that treatment plan?
I do. He talked to me about in 2015 when he first went to therapy, he was finding himself looking at materials and having thoughts about things that did not sit well with him, and he was having relationship problems and mood issues, and so he sought counseling at that time. So even without the added pressure of court order or legal involvement or anything, he went out to try to get some help, and he would go back as needed to get that help. So I think he is amenable based on his past behaviors, but also in talking with him. It was obvious to me at various points in the evaluation process that he had a lot of remorse for what he had done, that he did not want to get back to that space that he had been in, that led to those behaviors. He was compliant with medications at the jail. He was doing all the things that I think anyone in that situation can do to demonstrate some amenability to interventions.
And finally, do you believe that Mr. Clear, based upon your analysis, that he has, tell the court what level of tolerance there is for his risk to reoffend?
So my impression, based on the information that I got, the measures that we have available to use at that time, was that he's a relatively low risk for reoffense. So we talk about static and dynamic risk factors, and I think I've said all this to the judge before, but the only static risk factor that he had, based on the measure that was used, was his age. And now some time has passed, and he's actually coming up to that cutoff point of 35, where even that risk factor becomes less important. But again, the dynamic risk factors really focused on, there's some sexually deviant interests or behaviors, substance abuse, relationship problems. I'm sorry. It's too long, obviously. So the 4 factors in terms of sexual deviation, major mental disorder, which would be the mood disorder that I believe is bipolar 2, but certainly there's some depression, some anxiety, substance abuse issues, and then relationship problems. So those are the 4 dynamic risk factors that were problematic, all of which, I would consider manageable. And, he was free from substances at the time I saw him. Mood was better managed than it had been before. So just addressing sexual deviancy and maintaining substance free and then dealing with relationship issues, I think certainly manageable through outpatient therapeutic services.
And so, do you believe that he meets the criteria for community-based treatment?
I do. So when we have folks that are low risk, we typically recommend outpatient services. And here in the state of Florida, you're not, that I know of, going to get such services in the Florida Department of Corrections. So outpatient is typically the best chance to get that sort of intervention and rehabilitation.
I have no further questions.
I just wanted to go briefly a couple things that you addressed in your report. On page 6, you discussed in 2014 he developed a small fantasy of having a sexual experience with a person of an underage persuasion, and that he found that thought exciting. Is that correct, ma'am?
Yes, ma'am. That's what he told me.
And also you indicated that he ended up feeling badly about it, so he did seek out the services of a support group at that time?
Yes, he had gone online and found, it's called VERPED. So this is a online group of individuals that identify themselves as pedophilic, but not wanting to act upon those urges. And so he kind of went into this group and began talking with others to see essentially if he fit with those people.
And then you also mentioned that he additionally sought some treatment in 2015 for anxiety and depression with stepping stones. Is that correct, ma'am?
Yes, ma'am.
And then again, he sought treatment in 2016 for some relationship problems. And at that point, the counselor indicated that he has an inclination and is attracted to children, but he's never acted on. Is that correct, ma'am?
Yes, ma'am.
And then also you indicated that he had another, went back into treatment in 2017 where he was having some relationship issues and again sought some treatment for anxiety and panic symptoms. And then with Ms. Hines in Peachtree City in Georgia, 2019, he again sought help for depression that was related to his relationship. Would that be accurate, ma'am?
Yes, ma'am.
And then finally, you said the ADHD that he talked about, but we really haven't seen anything from that because it was too early in the game. He never was able to seek the treatment, just had some meds prescribed.
Yes, ma'am.
And then finally, you also talked about the fact that on page 6, you talked about the problematic sexual interests did not present again until late 2018 when he was trying to cope with various stressors in his life. Is that accurate? And that the viewing of the child pornography was actually very exciting to him. It was like jumping off a cliff or very exhilarating. So he was excited by the child pornography, according to your report. Is that correct, ma'am?
Yes, he described it as being similar to an adrenaline rush.
Nothing further, ma'am. Thank you very much.
Yes, Judge. So let's unpack that a little bit, because the state lobbed just some loaded topics. Tell me if you agree with this. it can be pretty common amongst people in the criminal justice system to believe that those that view child pornography, that there's some causal connection to being a pedophile and actually acting upon that.
I think that's a fair statement.
Okay. Is that far from the science that you understand?
Yes, sir.
Okay, so can you tell the judge a little bit about that?
So certainly there are individuals who have pedophilic interests and who engage in those kinds of behaviors. What I am seeing more often than not are individuals who are online looking at normal pornography, however we want to define that, it's different for everyone, and then they happen upon child pornography, and it sounds like a silly excuse, but it really is what happens, that they don't go looking for it necessarily. Certainly some people do, but a lot of folks happen upon it. It's not where they start, but it is where they end up, and then they get arrested. The research is telling us that most people that have these charges of child pornography do not go on to offend, to commit a contact offense. Certainly some do, but the percentage is very, very low. People that have these kinds of charges do show greater sexually deviant interests, but again, whether they act upon them is usually very low unless they're showing high degrees of antisocial personality traits or just sort of a general criminal inclination and ability to sort of manage themselves in society. So again, people that have these charges are not by nature high risk to go out and commit a contact offense. And they're not even really high risk to go out and commit this kind of offense again. Usually the legal process leads to desistance. It's not anything they want to do again.
And would you say that that notion that Ms. Basso stated in your report, talking about that exhilaration of like driving off a cliff, would that be consistent with somebody that has that bipolar 2 disorder when they're in their depressive state, to find something that would lead them to feel that way?
Yes, and we kind of circling back to the coping strategy, maladaptive coping strategy, obviously, but when someone is depressed, they may seek out things to give them an adrenaline rush or a dopamine hit or whatever it may be, and that's why you have people that rely on substances to try to help them feel better or feel different than they do. And certainly when someone is in a manic or a hypomanic stage, they're going to be dysregulated, and they're going to do things. They're not going to think about things before they do them. They're going to be impulsive. So I think when you have any sort of extreme mood state like that, it's going to increase the risk of a problematic behavior.
Thank you.
Doctor, a couple questions.
Sorry.
One, when you were speaking about actually acting on child pornography and doing something physically outside, that's been consistent. The thoughts on that, the studies on that have been consistent, that people that view child pornography traditionally don't act on it, and that's been consistent for over 4 years, correct?
Yes.
You talk about all these times, and the state brought it up, all the times that Mr. Clear had treatment back, I think you said 14, you certainly said in 15. He's had all these things in the past. Why would this be any different, other than he's been through the legal system now? But if he's amenable to treatment and it didn't work at 15, Why would it work now?
So when he went to treatment in 2015, he had 9 sessions between July and December. And the focus of treatment was, at that time, low sexual desire, that he was in an unhappy marriage, anxiety, marriage problems, and history of childhood abuse. So the focus of treatment that time, she had offered diagnoses of hypoactive sexual drive, partner relationship problems, and then physical abuse of the child victim. So those were the things that she was focused on, sort of addressing these, what are the immediate concerns that the person has. I don't think that she fully appreciated the severity of the mood issues that he had and had been having for a long time. Because when someone comes in and says, I want to address these problems, as a therapist, that's typically what you work on. And that 9 sessions across several months, to me it doesn't sound like a lot, but maybe it was, I'm not sure. He went back to therapy in December 2016, so a year had gone by. He was having problems again. And then was absent another time, went back in July 2017, these specific problems. So I don't know that the treatment he was getting was addressing the full breadth of the issues that he was having or that were developing at that time. And there were no medications on board, so that was another, I think, absence of intervention. He was referred to the ADHD evaluation because of complaints with concentration and things like that. And the evaluation that was done, no disrespect to the person that did it, but it was extremely limited. And it didn't rule out the other things that could have been contributing to his specific complaints of concentration difficulties and all that. It was kind of evaluation done, in my opinion, was riddled with confirmation bias. And so it was like, we're just going to focus on this ADHD. And I'm kind of glad he didn't take ADHD medications because it probably would have worsened his mood state. Blessing.
Thank you. Do either of the attorneys have any questions based on the court's questions?
No, Judge.
May the doctor be released?
Yes.
Thank you, ma'am. Thank you, doctor. The next witness.
Judge, would call my client. Would you like him to get on the stand?
Mr. Clear, if you'll please come to the stand.
Yes, sir.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Thank you. Good afternoon, sir.
Afternoon.
You've had a long time to think about today, haven't you?
More than a long time.
You're lucky enough that your mother that flew down here to come see you?
Yeah.
And what you don't have here is your child, is that right?
No, I don't.
Okay. Albeit you have fought for custody while being incarcerated, right? To some extent.
Yes, actually, Your Honor, you actually ruled in favor of, they tried to get a change of venue to a court in Texas for his stepmother. And you were the one that ruled against the change of venue, and that was instrumental in my child mother getting our son back. So I really very grateful for that. Very, very grateful. Because I mean, essentially, he was kidnapped. Pretty bad.
What did you do for work before? So you've been incarcerated for about 40 months, right?
40 months, yes, sir.
Okay. Before you were arrested, what did you do for work?
Immediately before my arrest, I was a data link field engineer, which is kind of a fancy word for like radio technician. I also did a lot of IT. I worked on base. I had a secret clearance and worked with a lot of vendors from honestly around the world to come and test their products in our data link test facility that I worked at. I was a subject matter expert for data links. I was also kind of like a
second line defense for cybersecurity, and did TUI a lot to also help people who are having equipment issues overseas, around the country.
And before that, were you in the Air Force?
Yes, I was.
For how, 4 years?
4 years, just one term, yes, sir.
Okay. I want you to tell the court about the events that led up to your arrest. Kind of the environment.
The environment? Are we talking about
all the things that were happening in Tyler Clear's life on or around that fall of 2019?
So, 2019, around that time, I had finally, I would say, gotten myself into what I consider a better place. Because essentially a year before that, I was in an extremely dysfunctional relationship. And I was still currently having a lot of problems at work, mostly through, I feel like, what was considered like age discrimination, and maybe some discrimination on like personality based on like some of the manic tendencies I have. There was a lot of tension at work. And about a year before that, my grandma died, and I wasn't that very well. And, around 2019, like I said, I had just gotten to a point where I was trying to get myself right because I kept putting myself in situations that were not good for me mentally. Especially the dysfunctional relationship, and then, once that crashed and burned, you're trying to find another one immediately, to validate myself or make myself feel good about myself.
Did you try to, times before that, you talked about feeling those manic feelings, some depressive feelings.
Mm-hmm.
Dr. McDonald talked about, those instances where it was reported that you went and reached out for help.
Sure.
Did anybody tell you to do that, or is that something you did on your own?
I did it on my own. Why? I felt like there was something wrong. For most of my life, I've had, I would go through these periods of, I would say, hypermania, where I was extremely motivated, very energetic, and then I would crash, and I would have like long depressive episodes. And the worst part wasn't necessarily it was definitely the depression, but it's like the craving for like, well, what happened to this other guy? What happened to this person that was motivated? Not only that, but like the judgment. It's just like, why can't you always be the hypermanic one or whatever? And sorry, I lost my train of thought.
No, you're fine. Was your time in the Air Force, how did that play a role in kind of your mental health? If any.
I'll be honest, not much. It challenged me. Like, it wasn't so much my time in the Air Force, it was like my marriage during the Air Force that was really the more trying part. Once again, like, I had issues with, wanting to get out of bed, to go to work. But I'm in the Air Force, I have to go. It's illegal to not go.
Sure.
And like also sometimes you butt heads with people who were appointed over you because you didn't think that maybe they were making the right decisions, but they were technically over you, so you had to listen to them and follow their orders, and that caused a lot of strain.
Internally or externally? Like, were you written up?
No, never. Internally mostly, like, lots of, internal rants or rants to to fellow coworkers.
Sure. At some point, pornography entered into your life as an outlet for stress. Is that accurate?
Yes.
Okay, tell the court about that.
Well, I mean, when I was young, I hate to like say these things in front of my mother because, you know, she was a guardian, but like, you know, she didn't really keep too much track of what I was doing. Back in the early days of the internet, and, you know, a young boy is gonna go off and explore, find what's out there.
Do you feel like that you often used it as a outlet for when you weren't feeling good mentally?
Yes, absolutely. That coupled with, I would say, I don't know, maybe some of the, especially like when I lived with my dad, so maybe like the covert, you know, like, I don't know how to describe it. I can't articulate it.
So we need to understand at what point did viewing of, lack of a better term, legal porn to illegal porn enter into your life, and tell us the how and the why.
Okay. Well, with the illegal, that entered in 2018, literally days after my grandmother died. I was, up to that point, I was going kind of off the reservation, as it were, with pornography anyway. I think Randy and I talked about this, how, you know, even though I don't have a sexual preference for like transgenders or anything like that, I would look up that kind of porn because it was extremely novel. In my opinion, very shocking, I would say. And I found that to be
okay.
And then that I would consider like below the case of the charge. That was probably the most extreme I guess I've done.
Then at some point thereafter, illicit material became a topic.
Yes.
Was that over a long period of time?
How do you mean?
Well, you tell me. So when at some point you decided that you wanted to search out child pornography.
I don't know if it was necessarily search out, because of my, I would say, interest in working with cybersecurity. Like, you know, let's say, with working in cybersecurity, you know, you hear a lot about like the deep web or the dark web, right? And so if you're interested in cybersecurity, you kind of see what kind of things are involved in that. And, you know, as far as exploration goes, you know, I was aware of the presence of child pornography on the dark web well before any of this happened. And, you know, when I had explored the dark web previously, like, you know, I felt it was, well, there's nothing for me here. You know what I'm saying? Like, it's just like extremist blogs, people talking about drugs and child pornography.
So at some point you decided to inquire into child pornography.
Yes, and it wasn't like it was just like a random thought, like, you know, hey, I should, you know, like out of nowhere, where it was just like, let's just try this instead. And it was more like, you know, the more extreme things were not novel enough. And there's that little voice in the back of your head that's like, well, there's that, you know where it's at.
Okay, so your exploration into child pornography, how long was that episodic period?
That was a single night.
So everything that happened, you know, the state talked about, well, they obviously charged you with 30 counts.
Yes.
And then they talked about in their letter that I showed you when I was up at the jail yesterday, that there was some child erotica and and some other information on your devices.
Mhm.
Are you telling this court that that was one episodic night?
One episode, yes.
Okay.
Like at least 4 or 5 hours.
Do you think that, well, as we sit here today, you've had, what, 40 months to think about what you did?
40 months, yes.
Do you accept the responsibility for your actions?
Absolutely.
Okay. What, tell us what responsibility is. You tell Judge Brown what responsibility, like what you taking responsibility is. What have you learned?
Taking responsibility is being cognizant of the fact that in the beginning, I had to maintain a couple of delusions. One, that, you know, what was being viewed was not real. I think Randy and I, McDonald, talked about this. You know, she asked me, she's just like, the content that you were viewing, did it seem real to you? And I said, absolutely not. I remember kind of breaking down into tears because it's like, you know, like I finally admitted it to myself, and it just sounds preposterous at that point because it is. And it's not okay. You know, I take responsibility because I mean it's pre-victimization. It's archive of abuse, and it's not okay. I'm totally ashamed that this ever happened. And I don't want to be a part of that. I don't want to contribute to anybody's suffering. I don't want to re-victimize anybody. I don't want to. I don't want to, you know, increase demand for it, especially.
So let's talk about what you want to do. Do you want treatment?
Yeah, absolutely.
Okay, so I guess it just culminates with this. Dr. McDonald stated a battery of treatment that she thinks is appropriate. Frankly, I discussed that with you at length, didn't I?
Yes.
And I asked you point blank, is this something that you're willing to commit to?
Absolutely.
And tell the court why you believe that this court should take a chance of giving you a departure, to give you the opportunity to do treatment.
Yeah, there's no another question, right? I mean, I feel like that I got arrested at a really inopportune time because, you know, I was trying to get myself out of all these bad situations, like with my girlfriend. I mean, that was the big step. I mean, we had just an extremely toxic relationship. It brought me so much misery and a lot of suffering. And, you know, I felt like I was getting to a point where I could finally do real work on my mental state. However, I don't think after being incarcerated for 40 months, I almost, it's kind of weird to say this, but it's almost like divine that it happened because if I hadn't had everything taken away from me, I don't know if I could have developed, you know, the basic skills to just live with myself. Because, you know, on the outside, if you get into depressive periods, you know, the whole wide world is out there to help you cope in whatever way you want. And, you know, you get a prison, you get incarcerated, and you have nothing. And that is an extreme challenge. And I feel like I almost failed because, I mean, I had some serious suicidal ideation because I didn't know how to cope with having nothing. And, you know, the manic depressive periods don't go away just because you're somewhere else. You know, they're there, and now I have nothing to help me deal with it. So, I mean, ultimately, I learned how to deal with myself. I mean, I learned how to live with myself. And, like I said before, I don't think I was really in the right mindset to truly do any kind of work. I mean, it was almost, the best analogy I can put it is just like, before incarceration, it's almost like being lost in a forest and you're just kind of like trying to find your way and you can't. And then at some point you find a path and you're just like, this might lead somewhere, but it might be too much for me to handle on my own. So I feel like I do need, guidance and treatment to build upon some of the basic skills, coping skills that I've learned while incarcerated. I have a lot, in the Air Force and for my contractor job, I felt like I was part of something bigger, but on a macro scale. Because, my jobs mostly involve national and sometimes international security too. And it was good, but I feel like the real work is going to be in the opportunities on the micro scale with people who are also suffering. Because being in jail, you see a lot of suffering based on mindset, and I feel like that's where I was. It's like bad coping mechanisms, bad mindsets, and people have very self-destructive mindsets. And I've never really been so exposed to this as much as I have been in jail. And I feel like I want an opportunity to go out and share some of the skills that I've learned. Not only that, but I still have a lot of. I'm an able-bodied person. I still have a lot of skills to offer, and after this COVID epidemic, I feel like more than anything, the world needs able-bodied people to do the jobs that can't seem to be filled. But I'm talking about the needs of society. We need healthier-minded people. We need able bodies. What's good for society is good for me. I'm not separate from it, and I don't want to be. I don't want to detract from society or bring it down in any way. I want to try to help enrich it and build it.
We talked a little bit about this yesterday, and just in kind of closing, but tell the court what it means to be able to go through this treatment as also an additional method to get back into your child's life.
Oh, yeah, absolutely. I have a child to support out there. One of my biggest sticking areas is that, I'm not out there to provide for him, because he lives with a single mom, and she struggles quite a bit, and I know they were really relying on me a lot of times to help provide support. Not only that, but a kid needs his father, and it's almost impossible for me to be here or be there for him behind bars,
No further questions.
Thank you. To the state.
No, Your Honor, thank you.
Mr. Blair, one question. Explain to me a little more, and I may have written this down incorrectly.
Okay.
I thought you said something to the effect of got arrested at a bad opportune time.
At an inopportune time.
Inopportune.
Yes.
Tell me what that means to you.
It means that I was doing something about some of the detrimental environments I was putting myself in, mostly destructive relationships. And I finally moved in with myself moved in by myself, excuse me. And that was a really big first step, just because I was still working on a lot of, I would say, self-worth and self-respect issues, because I almost felt like I was nothing without another person, being in a relationship. And it's like it was kind of rough at first to get out of that situation, but the more I was exposed to living by myself and just learning to kind of live with myself a little bit more, that it was helping a lot. So I guess it was really inopportune, because I felt like I was getting on the right track.
Thank you. Either of the attorneys have any questions based on the court's question? No, Your Honor, thank you.
No, Judge.
Thank you, sir. You can say that. Mr. Clerk. Mr. Patel, any other evidence?
No, Judge.
Did you state any other?
No, Your Honor, thank you.
Mr. Patel, argument, how do you want to do this since I need to look at the report? Because again, in the future, flag me on what I need to do my homework.
And my apologies, Judge. How does the court want to handle it? I certainly don't want to put Mr. Clear in an inadvantageous position by the court not having the benefit, especially when we're asking for a downward departure based upon the report.
I understand. Well, either I can take closing arguments from y'all now, take it under advisement, and then I think we're probably just slammed on Monday. It's an understatement. I think we need to come back for a sentence. I don't think I should send the sentence out. I've never done that in the past. I don't know legally if I can do that. What's the next date we have?
A miscellaneous at 2:30 next Thursday.
Why don't we do that?
I can't, I think both Mr. Shaw and I aren't available next Thursday. Is there anything the week after?
That's his jury trial weeks, the 2 weeks following after, so the next thing after that would be April 10th.
I just need to make sure that I've got, clerks here, court reporters, everybody.
Yep, Judge, we have a hearing. I think Ms. Botho is going to be here on April 10th because we've got a period hearing.
Part of that, but
Um,
we can make it happen. I've got Division 1 as well, but we'll figure it out.
I know that with his mom, he traveled here, and I was hoping to rule quicker than that. But again, Monday is just going to be really, really long because I put a lot of folks from 404 people on Monday, last Monday, to this upcoming Monday.
And I'm certainly not opposed if the court would like to take a brief recess to review it. I don't want to put the pressure on you, but.
Well, we've got other folks. And we weren't exactly real fast. It's 10:05. We're going to do the other cases. As far as closing arguments, do y'all want that? What do you want to do with that? Do you want to do that now? Do you want to do it after I've finished my homework and before I sentence?
Your Honor, perhaps the court would wish to review the report because we're going to be referring to it, and that way the court has the benefit of that report.
Okay. Yes, sir.
Yeah. So we should probably just do the closing after you review the report.
Okay. So I'm sorry, Mr. Clear, and to your mom. Again, I do whatever homework I know I need to do, but to go back and find a report that was filed in 2001, I just would have never thought about doing that.
2021.
2021. So we'll set it for April 10th. When is your other hearing on April 10th?
I think it was 2 o'clock.
2:30. April 10th, maybe 1:30. 1:30?
2:30, excuse me, Judge. This is what I have on my calendar.
Okay, we don't have a
Freaks all that day, so.
on April 10th, so we'll start at 1:30. Right?
Okay.
So 1:30 on April 10th. I'll hear the closing arguments and then sentence Mr. Clear.
And Judge, would you have any objection if his mother appeared by Zoom?
Not a bit. No, ma'am. You've been here this whole time. If you want to appear via Zoom, you certainly can. Thank you, Mr. Clear.
Thank you.
Your Honor, nothing further to add, these two?
Yes, ma'am. Mr. Gomez, what do you have?
So there was 2 things that are really time sensitive. One, I just wanted to let Mr. Clemens out here. We had a restitution hearing that was set. The state has been requesting a continuance on that, getting some more restitution judge work together. I believe also the listed.
Okay, yes, sir.
If you can just continue on one without, that would be what we would request. And
So
then
how long do you want to continue service?
just 1 month. So, miscellaneous days.
How about April 13th? You want it in the morning or afternoon?
Afternoon, Your Honor, this week.
Okay, so April 13th at 2:30.
And then, Your Honor, the other really time-sensitive matter that I have the victim here for the standard ground hearing, and they need to get back on their flight to Kentucky tonight. So if we could take that.
Is that Lambert?
Yes, Your Honor.
Okay, yes, sir.
Your Honor, may I approach? I have the order for Mr. Lee on the furlough.
Yes, sir. You need
I'll
us
show
first?
this.
Okay, thank you. Good, thank you, sir.
Yes, sir.
Your Honor, if I could excuse as well, I don't have any further business today.
Yes, ma'am, thanks.
Thank you.
Okay. Since we've been working all this time, we need to take a 5-minute break and then we'll come back and finish up the afternoon. So we're in recess for 5 minutes.
All rise. Court's in recess for 5 minutes.
Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office on North Verdon Boulevard for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
Hi, I'm Amanda Gaskin with Briarpatch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hi everybody, this is Alex again from the UPS store. Maybe I can let you in on a little secret. Did you know we're open on Sundays? Yeah, since February, probably one of the best kept secrets in Crestview, we're open on Sundays from 10 until 3 p.m.
Congratulations, Dixie Dan Powell, for your recent induction into the National Trial Lawyers Top 100. The National Trial Lawyers Top 100 is an organization celebrating premier trial lawyers from across the country who meet stringent qualifications as civil and/or criminal defense lawyers.
At Powell, Powell & Powell, we are a family of lawyers working together as a team for our clients. For more information, visit us online today at www.powelllawfirm.com.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office on North Verdon Boulevard for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestview.agent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
I have not filed it yet, Judge. May I make this Exhibit A to our...
Yes, sir.
Thank you.
Okay. Exhibit A to the defendant's motion to dismiss. Understand your ground is in the... Thank you, sir. Thank you, sir. Yes, sir.
And, Your Honor, I believe with that affidavit, the burden does shift to the state to make their case in this context.
That's correct, Your Honor. At this time, the state would call Deputy Ariel Plain to the stand.
Thank you, Deputy.
I would ask that the rule be invoked, Your Honor.
Okay, for those of you in the courtroom that may testify in this case, the rule of sequestration has been invoked. That means that you can't speak with one another or with anyone else about the case until you're called to testify. You can speak with an attorney one at a time before that time, but until the end of this hearing, until you're released, you can't speak about the case with each other or with anyone else. So if you'll please step out of the courtroom until you're called to testify.
Okay, Cameron, you just want to step out, go outside, and once you can testify, I'll meet you.
You raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Deputy, can you please state your name for the record?
Ariel Plank,
And where are you employed at?
Okloosa County Sheriff's Office.
How long have you been employed at the Okloosa County Sheriff's Office?
Coming up on 4 years.
Okay. Were you working the night of April 22nd, 2022?
Yes, sir.
I actually believe it's the morning of April 22nd. I'll correct that for the record. Where were you working at?
I was working on off-duty detail in Destin.
Okay. Where at specifically?
Coyote Oakley.
Did you happen to come into contact with the defendant, Mr. Jonathan Lambert, on that night?
Yes.
Okay. Can you describe how you came into contact with him?
I was approached and said there was a disturbance in the back side of the bar. And that's when I went inside, and the bouncers had flagged me down and pointed at the defendant.
Okay. Did you perform an investigation, or did you apprehend the defendant at that time?
Yes, sir.
After you apprehended the defendant, did you perform an investigation?
Yes, sir.
As part of that investigation, did you observe a surveillance video?
Yes, sir.
Your Honor, I believe, and you can correct me if I'm wrong, Mr. Kloss, but Mr. Kloss stipulated this is a Coyote surveillance video.
That's correct, Your Honor, I'm stipulating.
Submitted the evidence, is it State's Exhibit 1?
State's Exhibit 1.
Yes, sir, it's admitted.
I'm just going to play that video, it shouldn't be too long. And there's no audio, so I don't have to worry about that. Is that the surveillance video that you viewed that night?
With the exception of me running in, yes, sir.
At any point on the surveillance video, did you see the victim become aggressive towards the defendant?
Not one time.
At any point on the surveillance video, did you see the victim become aggressive towards anybody else?
At no point.
At any point when you were investigating this after the incident, did you observe the victim be aggressive towards you or anybody else?
No.
At any point in the surveillance video, did you see a weapon of any kind that was possessed by the victim?
No.
At any point in time during the night after the incident occurred, did you see the victim possess a weapon or hold a weapon?
No.
What did you observe the defendant do on the video surveillance?
I observed the defendant hold a beer bottle and then re-grip the beer bottle and strike the victim in the head.
You just watched the video. Approximately how much time was there between when the victim was separated by the bouncer and when the victim was struck with the glass bottle?
I don't know definite time, but maybe 30 seconds-ish.
Would you say that's an appropriate amount of time to de-escalate a situation?
Yeah, the victim never escalated a situation.
At any point, did you feel like the defendant was defending himself or some member of his group from the victim?
No.
Calls for speculation, objection.
Sustained.
I have no further questions, John.
Deputy, would it be fair to say that you didn't hear any of the words that were passed between the individuals in this video that we just watched? Is that correct?
Correct.
Okay, so you can't provide any testimony as to what was said, can you?
Yeah.
Okay. And there's some portion of the scuffle that happened before the video actually captures the frame of this area. It seems that the two people initially coming from outside of the frame come inside. You can't testify as to what happened before the two people came into the frame, can you?
No, sir.
Okay.
And I would like to add, I tried to get that video and that video camera was down.
Understood. And did you talk to any of the witnesses in the case? Do you remember who it was that you talked to?
Spoke with Kinsey Maloney.
Okay. And you,
Ryan.
I'm sorry, I didn't hear
Kinsey
you.
Ryan or Ryan Maloney.
Did you speak with anybody else?
And not that's named in my report.
And you were the lead investigator in this case, is that correct?
The lead case officer, yes, sir.
Okay, so you were the one responsible for this particular investigation, is that correct? Now, you would agree with me that there were more individuals involved in this scuffle in the bar besides Mr. Lambert and Mr. Hennessy, who's the complaining witness in the case? There were more people that were involved in the fight that we just watched on this video, right?
Yes, sir.
And you had the video, would it be fair to say you had the video within maybe 20 minutes after this incident happened?
Roughly, I don't know the definite time.
Certainly you had it within an hour of the incident happening, correct?
Yes, sir.
And Mr. Hennessy and all of his friends, Mr. Hennessy in this particular case is a complaining witness, Mr. Hennessy and all of his friends were still on the scene, correct?
I don't know where his friends were.
Okay. You didn't talk to any of his friends at all?
I spoke with Mr. Hennessy and there was one female that was with him.
Okay. Were you aware that Mr. Lambert was still on scene with his friends that were also in this video?
I don't know who was all friends with anyone. I had two groups surrounding me.
Okay, did you make any, well, let me just, Your Honor, may I address the prosecutor just about a logistical issue?
Yes.
I know that's not always,
Sure.
I just, what I was going to say is I can use my computer if you don't mind if I use your computer just to move the video forwards and backwards. Instead of changing up computers, Judge, I've got the same video, but I just wanted to see if this thing would be okay. And Deputy, this is the video that you were able to recover from from the actual Coyote Ugly Bar camera system.
Yes, sir.
Correct. And if I remember correctly, I think this is actually your body-worn camera is taking a video of a computer screen in the office. Is that right? Or maybe
Yeah, it's either body camera or cell phone. It's one of the two.
So this is not the actual original video. This is
Yes, sir.
you're holding a camera taking a picture of a computer screen when this happened.
I was unable to get a burned USB or CD.
Understood. And so if you can look where, would you agree with me where I'm pointing? Are you able to see the cursor as I move it?
You can stand up if you want.
Yes, sir. Can you see the pointer that I'm using?
Yes, sir.
Would you agree with me that this is Mr. Lambert, the defendant right here? That I'm
Not
pointing
at
to?
this point in the video, no, sir. I'd have to see him walk.
Okay, I'm going to move it forward just so we can identify who some of the parties are. Excuse me.
Yes, sir.
Okay, so we've identified at the very beginning of the video, before there's any fighting going on, that the defendant is actually standing. I'm going to point to him. This is 0000 on States Exhibit 1. We're at timestamp 0000. You would agree with me that this is the defendant, Mr. Lambert, right here, correct?
Yes, sir.
Okay. And did you ever find out who this person was here in your investigation? Did you ever try to find out who this person was? With the white shirt and the white hat?
If he was affiliated, then outside possibly, but I can't identify who it is.
Okay, do you have his name and any of the reports?
No, sir.
Okay. I'm going to move the video forward. Okay. Now it looks, to the best that I can tell, two new persons have come into the frame these two people over here, and you would agree with me that this person who has what appears to be khaki pants, shorts, I'm sorry, and then a shirt that appears to be a dark color, this person at timestamp 0004, you agree that that is Mr. Hennessy, correct?
That is the victim, yes.
The victim, Mr. Hennessy. And how about this person who's pushing him right there? Do you know who that is?
No, sir.
Did you ever make an attempt, when you had the video, to see who was pushing Mr. Hennessy? Did you ever make an attempt to find out who it was?
I asked Mr. Hennessy if he wanted to pursue charges. He said no. At that point, I did not have a crime for that battery.
Okay. Well, isn't it true that Mr. Hennessy told you that the person who pushed him against the bar was the one who slapped him with the bottle? Isn't that true?
I'd have to look at my video.
Okay. If I were to show you Mr. Hennessy's statement, sworn statement, would that help refresh your memory? Okay. May I approach the witness, Judge? Excuse me. Do you recognize what that document is?
Yes, sir.
Okay, and that's a sworn document, is it not?
Yes, sir.
And that's the sworn document that was provided by Mr. Hennessy, correct?
Yes, sir.
Does that help refresh your memory about who Mr. Hennessy told you pushed him into the bar and hit him with the bottle?
Yes.
Okay, now that you've refreshed your memory, what did Mr. Hennessy say about the man who pushed him into the bar with respect to whether that was the man who hit him with the bottle?
Struck him with the bottle.
Okay. And it's true that Mr. Hennessy in his sworn document said, and I'm not going to read the whole thing, but the pertinent part is in the sworn complaint of Mr. Hennessy signed under oath says, suspect shoved victim into the back of bar and struck victim with beer bottle which broke on impact with his face. Correct?
Correct.
Okay. So Mr. Hennessy told you that the man that I'm going to point at on timestamp 004, the one who pushed him into the bar, he said that was the guy who slapped him in the face with the bottle. Isn't that true? In his sworn document?
Correct.
Okay. I'm going to move the video forward a little bit more. Okay. Now let me see if I can back it up just a second or so. Okay. In addition to the complaining witness and the man in the black t-shirt and the hat, two new people have come into the screen at this point. I'm going to point to this very tall gentleman, very muscular with a bald head. He's one of the bouncers at the bar, isn't that true?
Yes, sir.
Do you know his name?
Satchel, I think is what they call him.
Satchel? Okay. And so then there's another, and I did do a good job of stopping it. I'm pointing at the back of a young man's head here. This is a taller, blonde young man. Do you recognize him?
No, sir. I can only see the back of his head.
Okay. I'm going to back up a little bit. Now, so that young man that I described as a tall, blonde-haired young man, he has what appears to be in this a black shirt, in khaki shorts and tennis shoes. He just threw the man to the ground that pushed the victim into the bar, didn't he?
Yes.
Okay. So the man, Your Honor, may I ask Counsel Opposite something real quick?
Sure.
Your Honor, what I asked the state attorney was, I know the names of these people, and it would probably be helpful to the court if I just used proper names instead of using the clothing descriptions.
Yes, sir.
If I could do that, the state did not have an objection to that.
Sure.
Okay. So We have Satchel here, who's the tall bouncer that has bald head. We have this unknown gentleman right here, who's wearing khaki shorts and a black shirt, whose name I don't presently know. We have, I'm pointing to a timestamp 0007. This right here is Cameron Hennessy, the complaining witness, correct? And I'm pointing to where somebody's holding an arm across their chest. Is that correct? Right now, in the screen capture that we're at 007, the complaining witness, Mr. Hennessy, has got his back against the bar. Is that correct?
Correct.
And there's a gentleman that has his arm across his chest. And then behind, and this, just so you know, this gentleman's name right here, who's got his arm across Mr. Hennessy's chest, Your Honor, his name is Troy. And just for the purposes of the examination, I'll just refer to him as Troy. And then behind Troy, we can still see Mr. Lambert is there, correct? Behind Troy?
Or something, I don't.
I'll make the video move so you can actually see who it is.
Yeah.
You would agree with me. So now, Mr. Lambert, even though Mr. Hennessy, the complaining witness, is being held back by a man named Troy, Mr. Lambert is just standing there, isn't he?
Yes.
And except for the point where Mr. Lambert appears to hit Mr. Hennessy later in the tape, there's no other contact between Mr. Lambert and Mr. Hennessy, the complaining witness, is there?
No, sir.
Okay.
Well, other than physically, no. Verbally, I don't know.
Okay. So you leave room for the possibility that there's a verbal exchange between Mr. Lambert and the complaining witness, don't you?
I don't know.
Now, I'm sorry, I went too far. I'm backing up to timestamp 006, and we see the unknown, I'm just going to call him the tall blonde gentleman with a black shirt. We see him grab the man who pushed the complaining witness to the bar. His name is Tyler, and throw him to the ground. Would you agree with me that this unknown man in a tall blonde-haired guy in a black shirt throws Tyler to the ground? Can you see that happen?
Yes.
Did you have any knowledge that when that tall blonde-haired young man with the black t-shirt on threw Tyler down on the ground, it broke his wrist?
I have no knowledge.
Well, you had the video though, right? I mean, you were able to see what happened.
Yes.
And did you make any attempt to talk to the tall blonde-haired young man in the black t-shirt?
There were so many of them, sir. They were all outside.
Okay, they were all outside though, weren't they?
Some of them were.
Okay.
I had two groups.
And the man who got thrown to the ground was also outside, wasn't he?
I don't know. I did not witness him get thrown to the ground.
You have the video, right?
I understand what you're saying, but I did not see him afterwards.
Did you make any effort to try to identify who he was and what his injuries were?
No, sir, I didn't know he was injured.
All right, I'm going to move forward. We're at timestamp 009. Now, I'm going to Okay, we're at timestamp at 10 seconds. I want you to see if you can identify. Okay, here we come in. There's Mr. Lambert right here walking away from the complaining witness who is right here behind Troy. Do you recognize that the complaining witness? I'm pointing the pointer at him at timestamp 14. The complaining witness is still here with the gentleman with the white hat and light colored shirt. His name is Troy. That he's still there, and Troy is holding his arm across the chest of the complaining witness. You would agree that's what we're seeing, right? Yes, sir. And then Mr. Lambert is walking completely away from the victim, isn't he?
He's walking away, yes.
Yeah, and he's got 3 beers in his hands, doesn't he?
I don't know what he has in his hands.
Well, if I back it up a little bit, can you help me identify what's in his hands? Because you can, I know the video's hard to see.
I can see 2 beers. I don't know if there's 3.
Okay, so we can see at least he's got 1 beer in each hand, and he's walking around to the other side of the bar, completely ignoring Mr. Hennessy, isn't he? Well, it's best as we can tell. He's not really paying any mind to what's going on there.
Yes, sir.
And he's going around to the other side of the bar with a couple beers in his hand that it looks like he had just bought before. Is that correct? Yes?
Yes, sir.
Okay. Now we can still barely see, we're at timestamp 17 seconds, we can still barely see, this is essentially, I can back it up if you need to, but this is the elbow of Mr. Lambert right here, 17 seconds, correct?
Correct.
Okay. And, let's see if I can move forward to see Mr. Hennessy's. Okay, at this point, there's another scuffle that breaks out around the dog leg short end of the bar, isn't that true? And just for ease, can we say the long side of the bar is where Mr. Lambert walks from, and then the short side of the bar, because it's an L shape, right?
I believe so.
Yeah, so we can just say short side of the bar is over here, and then the long side of the bar is up here. Apparently, there's another fight that breaks out over here on the short side of the bar. Is that correct?
Correct.
I'm going to back it up just so, because I know it's hard to see, Your Honor. So can you see that there's another gentleman getting punched in the face over there on the short side of the bar?
I don't know if he's getting punched in the face, but he's leaning up against the bar.
You can see that he's being beaten, can't you?
Object to speculation.
Sustained.
I'm going to back it up to timestamp 17 seconds. Now, right here, that head that we see right there, do you recognize that to be where Mr. Lambert has gone?
I cannot positively identify him, no.
Understood. And then would you agree with me that at timestamp, excuse me, 26, we are now looking at the back of the complaining witness, Mr. Hennessy, right here, is that correct?
Correct.
And I know this shirt didn't come out very well in the video, but it's actually like a blue and white striped shirt, isn't it?
Yes, sir.
But it doesn't look that way in this video, for whatever reason, is that correct?
I didn't make the video.
So, this is Mr. Lambert right here, correct?
Correct.
This is Mr. Hennessy right here, correct?
Correct.
Do you see Mr. Hennessy lifting up the back left side of his shirt?
Pulling up his pants.
Do you see that his shirt is going up?
His shirt is raised.
Okay. Now, let me ask you a question. You've been trained to be very observant as a law enforcement officer, is that correct? And you were trained to recognize threats on the street, is that correct?
Correct.
If you had just been in an altercation and you saw somebody come up to you or standing near you, and I'm not going to do anything to you, but if you saw somebody come up to you on the street standing like this and go like this, what are you going to think?
The defendant is looking away, so he doesn't even see
That's
it
my
like that.
question. If I come up to you on the street and do this and you don't know me, what are you going to think if I start reaching behind my back?
Let me see your hands.
About what?
Let me see your hands.
Why?
The unknown.
It's a threat to you, isn't it?
It's an unknown.
It's a potential threat, isn't it?
Objection, ask and answer.
Sustained.
Okay. We're timestamp 37 right here. At the time that Mr. Lambert hits Mr. Hennessy with the bottle, Mr. Hennessy has his hand back here under his shirt, doesn't he? Isn't that what the video shows?
It's on his hip.
And his shirt is up in the back, isn't it?
It was raised, yes, sir.
That whole time he had his hand behind his back, didn't he?
It was on his hip.
On his hip?
Side.
Now, do you know whether he had any type of weapon on him at this moment in this video?
I do know when you enter the bar, you have to go through a pat down and a security scan. So like medical, the like handheld medical detector, they swipe your body and then the bouncers physically pat you down.
Okay. Do they do that every single time? And can you testify that they did that to Mr. Hennessy in this case?
I cannot testify. I can only tell you what I've seen in the past.
Did there come a time when you walked up to the ambulance where Mr. Hennessy was receiving treatment and asking some questions?
Yes.
Okay. And you recall asking whether they were able to catch the guy who did it. Did you hear that particular conversation with Mr. Hennessy?
I'd have to refer back to my body camera. I don't recall.
Do you remember Mr. Hennessy telling you or another law enforcement agent that he hoped that kid dies, referring to Mr. Lambert?
No, sir.
Did you ever hear that in the video or hear Mr. Hennessy say that?
No, sir.
Is it fair to say that the only people that you talked to that are in this video were Mr. Hennessy? Did you talk with Mr. Lambert? Did you say?
I did speak with him.
Okay. And
I believe it was a sworn verbal statement.
okay. And then you talked with the young lady who said she was a witness, is that correct?
Yes.
And you didn't talk to any other witnesses besides having to take statements?
Regarding statements, no.
Okay. Nothing further, Your Honor.
Thank you. Mr. Gomez?
I just wanted to bring up just one point from the video. This is at timestamp 37. I believe counsel for the defendant had asked you, he has his hand behind his back here. At this time in the video, I think you also mentioned that he re-gripped the bottle. Is that what you're seeing on this right now?
Yes.
Do people normally drink the bottle?
Objection calls for speculation.
Let him finish his question.
Yes, sir.
Do people normally drink from a bottle when they're holding it as such by the neck?
Object to speculation.
At this point in the video, has the defendant even seen the victim and where his hands are placed?
No, sir. He's approaching him.
And he's already re-gripped the bottle? No further questions, Your Honor?
Can you redirect?
Court's indulgence, please, Judge. Nothing further, Judge. Thank you.
And the officer be released.
Yes, Your Honor, that's fine with me.
Yes, sir.
Thank you. Thank you so much. You're released. Thank you. Whitney.
I'd like to call Mr. Hennessy, he's outside.
You don't mind Deputy getting Mr.
you have that.
Hennessy and asking Mr. Hennessy to come in?
Yes, sir.
Thank you, ma'am. Good, I thought, dang.
Please remain standing. Can you raise your hand? Do you swear or affirm that the testimony you're about to give is going to be the truth, the whole truth, and nothing but the truth?
I do.
Do you have any
Thank you, Mr. Hennessy. Can you please state your name for the record?
Cameron Hennessy.
Okay. And do you remember what happened the night of April 22nd, 2022?
To what I recall, yes.
Where were you at?
IODRB?
Had you been drinking?
Yes.
How much did you have to drink at the time this incident occurred?
I would say 3 beers.
Were you drunk?
No.
How did you come into contact with the defendant?
It appears after I was pushed, a scuffle or something broke out, and then as what I think to be his, him and his accomplices were being escorted out and kind of came face to face. And that is the first I recall of seeing this person.
Okay. When you guys came face to face, did you say anything to the defendant?
Not that I recall.
Okay. I've noticed that you said now that you recall. Is your memory a little bit fuzzy of that night?
Yes.
Okay. Was it a little bit fuzzy kind of right after you had gotten hit with the bottle?
Yes. Well, a little bit before that. When I got pushed, I hit the back of my head up against the bar. I had a bump on there for a few days.
Is it possible that after you had gotten hit with the bottle that you may have kind of like misremembered some things when giving your statement to the police?
Yes.
Okay. I'm going to play some bits of the video here. I'm just going to want you to kind of help us identify some people. So I'm going to just start it at 00 and play it until about, let's see here. Okay. This is the first time that we see you come into screen on this surveillance video. Do you by chance know who it is that was pushing you?
No. Personally, I believe it to be a friend of the defendant.
Okay. But you don't know for certain? Okay. How did he come to be pushing you?
He was talking to a friend that I went down there with, and I walked up. They weren't fighting or anything, but it looked like they weren't getting along too well. And I walked up, said what was going on and stuff, and this person seemed very, pretty angry, honestly, and rude right away towards me. And then what I remember, something along the lines of, you don't want to mess with us, and I was like, oh, what are you going to do? And that's about all.
Is that when you were shoved into the bar?
Yes.
I'm going to continue playing the video from .05. Okay. I kind of stopped it a little bit blurry, but there was an individual who came in and grabbed the individual pushing you. Do you know who that individual is?
Yes.
Who is that individual?
That is my sister's, my girlfriend's older sister's boyfriend.
And what did he do exactly during this part of the video?
From what I know, and he just shoved the guy down.
Okay. So he didn't take a bottle and hit that guy in the head because he was touching you, right?
No.
Okay. Okay. At this point in the video, there are two individuals right around you, is that correct?
Yes.
Do you know the individual who has his arm out on your neck?
I do not.
Was that a member of your group?
No.
Do you know the individual, or do you recognize the individual that appears to be right to the right of your shoulder by the bar?
From the video, I know that it's the defendant.
At this time, were you aggressive towards the defendant in any manner?
No, and I believe the video would show that because after someone puts their arm around your neck, I looked pretty calm and remained pretty calm the whole time, I would think.
Okay. I'm going to stop it over here. As I think you can see around the bar, there's another altercation that's happening. Is that correct?
Yes.
What was happening?
I do not have any recollection of what happened right then and there because just of when I got hit in the face, I do not remember.
Okay. Was one of your friends involved?
I don't remember, but I believe so.
Okay. What are you doing here at this point in time in the video?
Like I said, I don't have full recollection, but it looks like I'm just kind of seeing what's going on, see what's happening.
All right. Would you categorize yourself in an aggressive posture?
I would not.
You just performed an action, and I just wanted to know, what was that action? You seemed that you were reaching by your waistband. What exactly were you doing?
I put my hands on my hips.
Okay. Did you have a weapon in your waistband by chance?
No.
Do you recall if you ever told somebody that you had a weapon?
No.
Did you ever threaten anybody with a weapon?
Not that I know, no.
At this point, it looked like you and the defendant came face to face for a brief moment. Do you recall the defendant saying anything to you?
Not that I remember, no.
Do you recall saying anything to the defendant?
Not that I remember, no.
Is this you still with your hands on your hips?
Yes.
Okay. By this point in time, about how many seconds had gone by between when you were shoved into the bar and you get to this point?
I would say like 30, 40 seconds.
Would you say that in terms of your involvement in this altercation, you were pretty much, you had been kind of de-escalated and you were done with this situation?
Yes.
And you were just simply standing to the side with your hands on your hips?
Yes.
At this time, did you have any knowledge that the defendant had re-gripped the beer bottle that he was holding?
No.
Is the defendant looking away from you at this point?
Looks like it.
On that frame right there, I want to pause it at 40 seconds. Is the defendant being pushed out by the bouncer?
Here so.
Is the defendant also have his friend that was the one that actually pushed you, correct?
Yes.
And you and that friend are showing no aggression towards each other?
Yes.
Does it appear that that friend is actually trying to get the defendant out of the bar?
Here so.
What is that friend doing now to the defendant?
Looks like he's trying to push him away or out of the bar.
So the friend doesn't appear to be concerned for his safety, and the defendant doesn't appear to be concerned for anybody's safety.
No.
What type of injuries did you suffer as a result of the incident with the defendant?
I had to get 60 stitches in my face that night. Severe swelling for weeks. Obviously a scar for life. Some nerve damage in my left side of my face. Can't smile straight now.
So, is it safe to say that your only physical involvement with this was in the very beginning when you were shoved into the bar by somebody other than the defendant, and that was that?
Yes.
And then you showed no more aggression or were involved in any form of aggression until you were struck in the face with a beer bottle?
Yes.
I have no further questions.
Mr. Hennessy, you would agree that not long after you went outside of the bar, you gave a statement to a deputy and told them what happened. Do you recall that?
Yes, what I thought happened.
Okay. Well, you actually signed a sworn affidavit, didn't you?
I guess so, yes.
And the sworn affidavit, you put your signature on it, correct?
I would think so, yes.
And you swore that everything that was contained in there was the truth, correct?
That I knew of, yes.
Okay. And it's true that the testimony that you're providing today is different than what you initially told law enforcement when they interviewed you, is that correct?
Yes.
And you're saying it's because you were having memory problems at the time, is that correct?
Yes, right after it happened, I really didn't know what happened, how I got hit, or anything.
Well, if I may talk about that a little bit, you said a couple times in answers to the state attorney's questions that not that you remember, so there's a lot that you don't remember, is that correct?
Yes, that, yes.
Did I hear you correctly when you said that you're not able to remember what, if anything, that you said to Mr. Lambert before he hit you? Isn't that true?
Yeah, you could say that, but it looks in the video that he's looking away from me and I'm not really looking at him also.
Yeah, but that's not the question. My question is simply, you don't remember what, if anything, that you said to Mr. Lambert before he hit you. Isn't that true?
Sure.
Okay. So,
Probation, I don't think there's anything else that you need to be here for. In the future, stand up and say, Judge, can I go? Because I don't think there's anything else. Okay. Thank you, ma'am. I'm glad that you had that call. Thank you, ma'am. Mr. Cox, please.
yes, thank you, Judge. So it's fair to say that you may have said something to Mr. Lambert before he hit you with the ball, and you're just not able to remember it. Isn't that true?
Possibly.
And when the state attorney asked you if you had made any threats to him, to Mr. Lambert, before you got hit, I recall your answer is not that I can remember. Is that correct?
Well, yeah, I said that, not remember. And if you look at the video, it didn't look like I ever really touched or saw him while I walked over there.
I know, but my question was, did you say anything? And we're looking at the back of your head, right? So we can't see whether your mouth
I'm
is
saying
moving.
that I would say no because I never even came in contact with him until that moment, so I would say no.
You were interviewed at some point by an officer when you were in the back of the ambulance, and you said that you hoped that Mr. Lambert died. Why did you say that?
Angry.
But you don't deny that you said that, correct?
No.
Besides the part of the video where it appears that Mr. Lambert hits you with the bottle, do y'all have any other interaction?
No.
Do you have any idea why it would have been that he hit you?
Objection, speculation.
I can rephrase, Your Honor, and to ask it better. Do you have any personal knowledge from any interaction with him or witnessing anything that evening that would give you personal knowledge as to why Mr. Lambert would have hit you with the bottle?
No.
Could it have been that he perceived you as a threat?
Maybe.
I didn't hear you.
Maybe.
And why maybe would he have possibly thought of you as a threat?
I mean, anyone could think of anyone as a threat.
I'm sorry?
Anyone could think of anyone as a threat.
Okay. And in this particular video, I'm back it up. stop right here. We're at timestamp 4 seconds. I'm pointing the pointer, that is you right there, correct?
Yes.
Okay, and this young man with the light colored hat and dark colored shirt on is the person that you said pushed you into the bar, is that correct?
Yes.
And I believe, if I recall your testimony correctly, you said that there was some type of interaction with this young man. And just for the purpose of this hearing, his name's Tyler. I'll call him Tyler, just have a name. Tyler, and you were here at the bar. What happened with you guys? What happened before you guys got onto the screen?
I said earlier he was talking to a friend of mine. They weren't getting along. I walked over. And what I said earlier happened.
You grabbed him, didn't you? You grabbed Tyler, and that's why he pushed you into the bar. Isn't that true?
No.
You deny that?
Yes.
Okay. This person right here, we're at timestamp 6 seconds. Blonde hair, taller, young man with a black shirt and khakis. I think you said that it was your girlfriend's older sister's boyfriend. Did I get that right?
Yes.
What's that young man's name?
Tyler.
Tyler what?
Hoppus.
Spell it for me.
Like H-O-P-P-E-S, I think.
H-O-P-P-S?
I think. E-S.
H-O-P-P-E-S. What city does he live in?
Lincoln, Nebraska.
Is he still dating your girlfriend's older sister?
They're engaged now.
They're engaged? And you see him coming into the screen here. So we've got two Tylers. You would agree with me that your Tyler from your group throws the Tyler from the other group to the ground. Is that correct?
Yes.
Did you know that when Tyler Opus, is that how his name is pronounced?
Hoppus.
Hoppus threw the other Tyler to the ground, did he broke his wrist?
No.
Did you ever go check on the guy that got thrown on the ground?
Are you talking about like right after or like after we were outside?
Either.
No, when we were outside, I was bleeding profusely and had a bunch of people asking me questions, so I didn't get the chance to do that. And after in the bar, it looks like right there, I was staying away from the situation. And why would I go see what he was doing if that's the dude I was coming into an argument with?
I'm going to fast forward a little bit. Now, up to this point, we're at 15 seconds, and we just saw Mr. Lambert walk from behind you, around you, and around to the short side of the bar. Is that correct?
Looks like it.
He didn't even really acknowledge you, did he?
Nope, neither did I him.
Didn't look like he was mad at you, did he?
Guess not.
And he was walking away from you?
Hear so?
He didn't hit you?
Not then.
Okay. And he walks around to the short side of the bar, and would you agree with me, let's just watch for a second, that you see a scuffle happening on the short side of the bar when I just played that, is that correct?
Looks like it.
And you would agree with me that there was Tyler Opus that was over there getting into a scuffle with somebody else, is that correct?
I guess that happened. I don't remember that scuffle either from getting hit in the head.
So at this point in the video, before you got hit with the bottle at timestamp 21, you can't remember whether or not your Tyler Opus got in another fight around the other side of the bar?
Want to say it again?
If I back it up a little bit, would you be able to see if you can identify him in the video?
Well, I just said, can you say what you just asked again?
Yes, sir.
I said yes, he's black shirt.
Yeah, the question that I have is, as we go around the short side of the bar, there appears to be another fight that's going on over there, and my question is Tyler Opus over there in that particular fight?
Is he?
Yes.
I don't know for sure, yes or no, probably, considering he threw the guy down and his friend went over there, so I would say yes.
And you saw somebody grab your left arm, correct? In this, right here, there's a hand that just grabbed your left arm. Do you agree with me right there? That's what just happened that we saw at timestamp 39?
Either someone's hand or my right hand.
I'll back that up and see what we can see. You would agree with me that somebody just grabbed your left arm, wouldn't you?
My left arm, no.
I'm sorry, your right arm.
I guess so, yes.
And you're standing there with your left hand on your left hip, is that correct?
Yes.
And it's under your shirt?
Yes.
Back up one more time, I'm going to catch it. Okay. Right here at frame 37, you made a point a second ago that the video showed that Mr. Lambert was looking to, I guess it would be his right, but here he's looking right in your direction, isn't he?
Oh, it looks like he's looking to the left, to my right a little bit, honestly.
And he's actually not on video as to what he's looking at as the whole time he's walking up to you from the short side of the bar. This is one of the first times where he's actually, his head is turned in your direction, is that correct?
Like I said, I think it's to the right a little bit, but yeah, it's pretty kind of close to me.
He looks back at you again there. So you agree with me, would you agree with me? I'm going to play it again because I know it happens so quickly. And looks at you once there, looks at you again, and then he hits you, is that correct?
Kind of looks like he's like looking away while he's hitting me to me.
Are you right-handed or left-handed?
Right.
So wouldn't you agree with me that the only time that you put your hand on your hip, under your shirt, is as Mr. Lambert is walking to you from the short side of the bar? In this whole video, that's the only time you ever did that?
Yes.
Course indulgence for 1 second, Judge. 1 second. Because you have said that you're not able to, not that you remember anything that you said to Mr. Lambert as he was walking by you, you can't deny that you said as he and his friend were walking by, I've got something for his ass. You can't deny that, can you?
No, but definitely didn't say that.
I didn't hear you.
I said no, but I mean, that's not something I would say. Like, that's not, I don't usually pick those words.
You can't deny that you said that, can you?
Guess not. But, I mean,
nothing further, Judge.
We'll go back to around 37 seconds, or a little bit before. What did you just do right there? So this is right when the defendant comes into the scene again. It's the first time we see him come back towards you. Can you describe to me your actions of what you did when you see the defendant?
took a step back and placed my hands on my hips.
All right. have no further questions.
I have one follow-up question based on that particular play of the video, Judge. It won't be very big.
There's no recross, but the state.
No, I object to that.
Okay, you can call him in your rebuttal case if you want.
No
Well,
problem, Judge.
it's your case. If you.
That's okay, thank you.
Next time, Mr. Klotz, if you want to preserve it, object to the question being outside of whose witness is this?
It's the state's.
Okay, so you'd have to object that it was outside of your cross.
I understand, Judge.
Is certain you can step down, may this witness be released?
Yes, ma'am.
No.
Okay.
Thank you. Please.
Okay, so if you'll remain outside. Thank you, sir. So the state, any other witnesses?
No other witnesses, Your Honor.
Mr. Klotz?
Your Honor, just briefly, before I would call any witnesses, I have argument that I believe the state has not met its burden of proof at this time. The state is required to show by clear...
You don't need to step out of the courtroom and just stay out of the courtroom and stay in the courtroom.
Yeah, they might use you for their argument, so yeah, you'll have to sit there for a little bit longer. We're going to try to get you out here shortly.
Mr. Klotz, you move for basically a directed verdict?
Yes, Your Honor. They haven't proved by clear and convincing evidence that my client did not have fear of serious bodily injury at the point. There is evidence. Court's indulgence. There is evidence that's been presented to the court through the deputy's testimony that somebody taking that particular stance would cause a concern. I understand that her testimony was not very strong, but the deputy testified that if somebody were to be standing in that fashion or approach her in that fashion, it would cause a fear of the unknown. I know I'm paraphrasing, but there is concern that was caused to Mr. Lambert by the posture of the complaining witness in this case. There is evidence about that. There is video to show that the only time that he concealed his hand up under his shirt and behind him was as Mr. Lambert was walking out. And I believe the state has to show by clear and convincing evidence that my client did not have a reasonable fear at that time that he might be the victim of serious bodily injury or great bodily harm, I believe is the standard. And I don't think they've met their burden, so we're asking for a directed verdict.
The motion respectfully is denied. Mr. Klotz, your first witness?
Yes, sir. May I consult with my client for 1 second? I have had extensive conversations about this issue with my client about whether it would be a decision to testify or not in this particular hearing, just based on all the legal issues that are involved with that. At this time, I would like to call him as a witness.
Okay. Please, if you'll come to the stand.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Okay.
Mr. Lambert, do you understand that you have the right to not testify if you don't want to?
Yes, sir.
Okay, so nobody's making you testify here today?
Yes, sir.
Okay, thank you. Mr. Klotz.
Thank you, Mayor, please, court. The Can you tell us your name, please?
Jonathan Lambert.
Mr. Lambert, where do you live?
Theodore, Alabama, Mobile.
And what do you do in Theodore, Alabama?
I'm a chemical operator at a chemical plant on Range on Road.
How old are you right now?
Turned 30 2 days ago.
Okay. We have walked through this video. Can you tell me what you and your friends were doing at this bar on this particular occasion?
Yes, I was down visiting. Also was getting married the following weekend, so we were down celebrating that.
Okay. And in this particular case, you've seen, as we've gone through the video, I've described a young man named Troy and a young man named Tyler. Have I accurately identified them on the video?
Yes, sir.
And it's fair to say that Tyler is the young man that pushed Mr. Hennessy into the bar. Is that correct?
That's correct.
And then Troy was the young man with the white shirt on who held his arm across Mr. Hennessy's chest?
That's true.
Okay. I'm going to go back to the start of the state's Exhibit 1, just the video. Have we accurately identified you as where I'm pointing with the pointer here?
Yes, sir, that's me.
And this is your friend Troy right here?
Yes.
Is that correct?
Mm-hmm.
Okay. And then in the black shirt with the dark shirt with the white writing and the light colored hat with Mr. Hennessy is your friend Tyler?
Yes.
Did you know who this young man was at all, who's we've talked about as the tall, blonde-haired young man who's also apparently named Tyler Hops, who is a friend of the complainant?
I did not know who he was at this point.
Okay. Now, when Tyler got thrown down in the next few seconds, he actually broke his wrist or broke his arm, is that correct?
That's true. Required surgery and everything. Yeah. Yes, sir.
And are we going to see in the video that Tyler actually moves away from the other Tyler Hops to go to the short side of the barn if we continue this a little bit?
Yes, sir. Actually ran from him. That's how he ended up on the other side so quickly.
So this guy right here, Tyler Hops, who's been identified with the complaining witness, throws your friend Tyler down, and Tyler runs away from him over to the short side of the bar over here?
Yes, sir. Actually made a loop. I watched him.
Okay. And then
there was a lot of people.
And Tyler Hops, who's the friend of the complaining witness, went over there and engaged him again? Is that
Oh, yes.
Are we able to see that happening when we get a little bit further in the video?
Yes, sir. On the side of the bar, you can actually see him punching him across the bar, which I tried to get Tyler so we could leave.
What we just saw right there around timestamp 21, is that your friend Tyler getting punched by Tyler Hops, the friend of Mr. Hennessy?
Yes, and I seen this.
Did you ever try to hit anybody or engage in the fight over there?
No, sir. I just wanted to get Tyler so we could leave.
Okay. And you heard us or saw us play the video where you were walking from the long side of the bar to the short side of the bar. You were holding how many beers in your hand?
I had two. I actually just bought another one for Tyler. He was going to the restroom and coming back.
Okay. Now, at this point, we can see this is you that I'm pointing to at timestamp 30 right here, correct?
Yes, sir.
And you have not been throwing any punches or pushing anybody up at all?
No, sir. My only interest was leaving with my friend because he was hurt.
Tyler was hurt because he had the broken wrist?
Yes, sir. He actually told me that whenever I come over there too, and I told him let's go, and he shook his head, yeah.
about 10 seconds. Can you see yourself in this video when you start moving towards Mr. Hennessy, the complaining witness? Can you tell me what you see Mr. Hennessy doing with his left hand as soon as you start moving towards him?
Yes, sir. So the bouncer was behind me and Tyler walking us out. And once I got to the corner of the bar, I noticed Mr. Hennessy standing there, and I already knew he was involved because of before. And so I stopped, and the bouncer was telling us to continue, and then Mr. Hennessy had stated what he stated, and
About what the victim stated?
Yeah, I thought he was about to say it, and I just don't want you to hear that, so.
Well,
No, I understand. I withdraw my objection.
Okay, thank you.
What threat of violence did Mr. Hennessy say to you as you were walking by?
do I have...
Objection, hearsay.
It's not hearsay. I'm sorry.
What's the exception, or why isn't it hearsay?
It's not hearsay because it goes to my client's state of mind. To prove his state of mind is not going to the truth of the matter served. It's going to show that he had a state of mind of fear. It's also a present sense impression of his understanding of what was going on in the moment.
State?
They're trying to prove the truth of the matter asserted. The matter asserted here being that he was in reasonable fear, and they're trying to use an out-of-court statement made by somebody else. The definition of hearsay.
The objection's overruled. You can ask.
Look, I'll lay a better foundation, Judge, but I'll get to the same question. Something happened that caused you to have a great deal of fear right around the time that Mr. Hennessy was walking by you. Isn't that correct?
Yes, sir. This was my only exit. When we tried to leave, he was standing there. I already knew they had beef with each other. So I stopped, and then he said, "I have something for his ass." And when he said that, I looked at the bouncer for the bouncer to assess the situation, and all he did was shove me into him, and I had to make a split-second decision. I mean, that happened that quick.
We're going to come back to that.
Okay.
But I want to ask you a couple of questions to lay some foundation. Do you have a carry concealed weapons license?
Yes, sir.
How many years have you had that?
Probably about 6 years.
Okay. And have you had some degree of training or practice in order to be able to carry a concealed weapon in Alabama?
Formal training, I mean, I'm a member of a shooting range in my house, and I have to go through training to be a part of that. And I hunt and fish and done all that all my life, so I'm outdoorsman.
So, and you did not you did not have a firearm on you this evening, did you?
No, sir, I'm not allowed to have one while drinking.
Okay. So you didn't have a gun, but you do have, are you familiar with the term situational awareness?
Absolutely.
What does situational awareness mean to you?
To me, I never sit with my back to a door. I mean, I'm always paying attention to everything. Any kind of act of violence can be, I take everything and I look at everything.
Okay. When you see Mr. Hennessy with his hand under his shirt behind his back, with the side where he's holding his hand away from you, what does that tell you?
To me, it points to, if not a knife, at least a gun or a knife. It's perfect posture for drawing a weapon. Okay. To me.
And there's been some discussion about you changing your grip on the bottom. I'm going to back up 10 seconds. I'm going to try to stop when you think you see that. Okay. Did you see right there around second 38? I'm gonna back up. And Judge, I'm sorry, I can only do a 10-second jump at a time if I have it. But around second 38, we actually see you shift your grip.
Yes, sir.
And that was after you looked at Mr. Hennessy and saw that he had his hand under his shirt behind his back in a posture to draw a weapon.
That's correct. I had no other option as far as defending myself. Both my hands were full. So once I seen him do that, I only did that in a situation where I had to use force, and I was forced into it by the bouncer. I wasn't able to stop, and he shoved us into past the guy, which I was out of arm's reach of him at that point.
How long would in your your experience in training, how long would it take for somebody to draw a weapon from behind themselves and shoot you?
Nearly instantly, especially with his hand already on it.
Did you?
And I was aware of there had already been shootings at this place before we ever went there.
I didn't hear you, I'm sorry.
I said I was aware of shootings already taking place at this particular bar before we ever went there.
How had you heard about that?
The news. And I have family that lives in Destin.
So you had previous knowledge that some people would be able, that people had come into the bar with weapons before?
I don't know for sure that they've been shot inside of the bar, but I know there's been shootings at the bar.
Did you fear for your life at the time that you made the decision to hit Mr. Hennessy?
I had feared that he was going to draw a weapon on me and shoot me or stab me, yes. I feared for my life.
Did you have any beef with him before you hit him?
No, sir. In the beginning of the video, I stood beside him for 5 seconds, looking dead at him and never fooled with him. I had no reason to fool with him.
And you heard Mr. Hennessy's testimony that he couldn't testify that he didn't say something threatening to you, but you specifically recall something that caused you fear of serious bodily injury. Is that correct?
Had he not said nothing to me, I walked straight past him.
And when he said those words to you, "I've got something for his ass," with him standing with his hand under his shirt, with the weapon side away from you, what did that make you think?
Well, Tyler already was telling me behind me that his wrist was broke, talking about how bad it hurt. So then we get to that, so I'm already on alert. And then I see him in a drawn position, which is, to me, textbook. And like I said, I see it as his left hand, but I don't know what hand he is, you know, in that position. I had to make a split-second decision, and that was, had I not had nothing in my hand, I'd have used my hand. But that's just how it fell because I had 2 beers in my hand.
That's all I have, Judge.
Thank you. Cross.
Okay, so I think you had stated earlier, this, where my icon is, that's you,
It looks to be.
and this is Tyler, your friend?
Oh, yes, sir.
Okay, I just wanted you to watch that for a second.
Okay.
Was Tyler pushing you back, trying to get you to go? Why were you walking backwards at that point?
Tyler was being shoved by the bouncer at this time. You can't see it in the video. I was standing there. And so, with that happening, I was also being shoved from Tyler because he was between us, me and the bouncer.
So your friend Tyler was also pushing you? Like, before you actually swung the beer bottle, Tyler was pushing you?
Once the bouncer shoved us, Tyler's hands were out, correct, and it caused me to move forward, but I didn't, with the guy in the posture he was in, I just didn't feel comfortable walking past him.
Is it correct that a very easy way to de-escalate a situation is to remove yourself from the situation?
Yes, that is the best way.
Okay. Why didn't you remove yourself from this situation? Why did you choose to swing the beer bottle?
In all due respect, if it's going to be me or him, it's going to be him.
Did it shock you to find out that the victim had no weapon on him at any time during the altercation?
I never was aware of that.
I'm sorry, the objection.
There's been zero testimony that he had a weapon at this point. And so it would be speculation for him to even testify about that.
The objection's overruled. You can.
Would it surprise you to know that there was no weapon found on the victim at any point during the night?
No, I wouldn't know that. But, I mean, I don't have x-ray vision, so I can't check him out before this happened in this split second, sir.
Okay. at this time that you swing the beer bottle, is it your position that you were only in fear for your life or your safety?
No.
So you were, as you asserted in your motion, you were in fear for your friend's safety as well?
Both of us, correct. And
Why was your friend pushing you to go out the door then?
because he was being shoved from behind.
So was your friend not worried about his safety?
My friend was worried about getting out with me. So he had a 8-foot guy behind him, excuse me, I don't know how tall he is, but the dude was shoving both of us. There was no stopping him.
After you strike the alleged complainant with the beer bottle, would you agree that your friend actually just pushed you more to get out of there? It wasn't by the bouncer, right? That was by your friend, because the bouncer is 3 feet behind him.
His hands on his back, but I mean, yeah, we was trying to get out because what had just happened. I mean, just walk away from the instruction of the bouncer.
Okay.
I didn't run or anything. I just walked off.
And you would agree that up until the point that the bottle made contact with the victim's face, you and the victim had not had any personal altercations between each other?
Not until he said what he said before the strike.
I have no further questions, Your Honor.
Redirect.
Questions on this, Your Honor? I don't have anything further, Judge.
Thank you. Yes, sir, you can step down.
Thank you, Your Honor.
Any other witnesses, Mr. Hawk?
No, sir, Your Honor.
Any other witnesses from the state?
No, Your Honor.
Okay, argument?
Yes, yeah, definitely please let, if I can let the victims go through the
Yes, sir.
I'll let you.
Thank you. Argument? Mr. Bivens?
I believe it's my brother, so I believe I have to go first.
Yes, sir, please.
Your Honor, I think in this case, I think there was some discussions early on about the victim not being able to necessarily remember some things. Clearly, there are some discrepancies in the affidavit of complaint. I just would like to point out, as we've seen in this video, not only was the victim shoved into a bar where he actually hit the back of his head on the bar, he also was hit with a glass bottle. So I just want to point that out to the court to help illustrate why there might be some discrepancies in what he's remembering right at that time. With that being said, this is one case where we're very, very fortunate to have a surveillance video that is able to clarify a lot of those discrepancies. As we were looking at, or as you're looking at the video, there is a lot of evidence that shows that the victim, at almost every single point in the incident, was the least aggressive person in that room, with the exception of the very beginning. And in the beginning, he's getting shoved into a bar. And after he's getting shoved, being held by somebody who's not even of his own party, he's calm. He's not doing anything. He has no, there's no, you don't even see him necessarily yelling. You don't see any sort of flaring of the arms. You don't see him bow his fists up. You never see him once say anything to the defendant at that point in time. And you don't see him really say anything to the guy that shoved him. I think it's interesting and a little bit ironic about, we're talking about the safety of the party of the defendant, when we saw a perfect example of how you could have handled this without a deadly weapon, and that is to remove that person off of your friend and simply push them or throw them to the side, as we saw Tyler in the video do to the other Tyler. So I think that's something that needs to be pointed out, is that there's so many other ways that this could have been handled if in fact that statement that was allegedly made was made. The only self-defense really that we had here that we can see is actually the Tyler throwing the other Tyler off of his friend. He actually physically saw that Tyler grabbed his friend and shoved him into a bar, and he pulled him off and threw him to the ground. That's the only evidence that we've seen and that we've heard of in this hearing. As you go forward, you see the fight or the altercation goes around the bar, and it doesn't even involve the defendant and the victim in this case. The victim has his hands on his hips. Okay, there was a point made by defense counsel when he was talking to the victim, and the victim's like, "You can see that I'm not saying anything," and the defense counsel goes, "Well, we can't see your back, or we can't see the front of you." Well, if he's going to take that position, the same position must be taken then with respect to the defendant and the victim. The defendant was in front of the victim. How is he going to see if his hand's underneath his shirt or not? As far as he knows, his hand's just on his hips. Having your hands on your hips doesn't automatically put you in a dangerous position. I think at one point in time, at 37 seconds in the video, I think that's a very common number that's been stated, we see the defendant kind of walk up towards the victim in this case, and you actually see the victim take a step back. That's the other. He keeps his hands on his hips. His hands are, at that point in time when he's seeing and he's right in front of him, his hands are right there. The victim makes no furtive movements. He doesn't do anything aggressive with his hands. He keeps his left hand here, and then as the defense counsel stated, at one point in time, somebody might have even had his hand on his right arm. So he was, if anything, more constrained than the defendant ever was, and he was the one that got struck in the face with a beer bottle. I think the video really does speak for itself. You have an incident here where the initial incident occurred. Almost 30 seconds goes by, or more than 30 seconds goes by, where the victim and the defendant are completely separated, and the victim is actually separated from the incident more so than anybody else, and he's standing off to the back. And then as the defendant, who, if you look at that video, he's getting kicked out. It looks like he's getting upset that he's getting kicked out. His friends are trying to tell him to get out. You see his friend push him multiple times to get out, and as he's getting out, he chooses to strike the victim in the face with a beer bottle, causing 60 stitches. This is not an instance of stand your ground. This is not what statute 776032 was meant to protect. It was meant to protect when somebody reasonably could infer that imminent threat or harm was about to come to them or a member of their party. It's very clear that the victim in particular in this case was not the aggressor at any point. The only point that you could maybe make an argument that he was when he was getting pushed backwards into a bar, and then after that was done, he had his hands up like, I don't even know what's happening. And then he walks around because people that he knows are getting into an altercation, and he's sitting there watching. He didn't go and jump in. There was one person who went over to the other side of the bar and got involved, and it's the defendant. So we see one fight happen, then it gets broken up by the bouncer, and then the defendant makes his way over to the other side of the bar, and it just so happens that another altercation occurs. And then as the defendant is being escorted out of the bar by the bouncer, he hits the victim in the face with a beer bottle. That is not self-defense. That is not what this statute was intended to protect. And so for those reasons, the state respectfully requests that this court deny the stand your ground motion and allow this to proceed to a jury trial where a jury can decide what happened that night.
Thank you. Mr. Platt.
Yes, sir, Your Honor. Thank you. Just a couple of kind of procedural basic things, Judge. The statute allows somebody to use self-defense in the stand your ground statute if they are lawfully in a place where they are allowed to be, which he is in this particular case, and was not engaged in any criminal conduct, which by all the testimony there was no engagement in criminal conduct. Therefore, Mr. Lambert doesn't have a duty to retreat under the statute. I'm going to read, if I may, Judge, and I'll get through it fast, but this is from the pattern jury instructions. I know you're very familiar with them. We've all used this particular instruction before in trials, but the pattern jury instruction for self-defense under the Florida statutes for stand your ground is in deciding whether the defendant was justified in the use or threatened use of deadly force, and I'm paraphrasing a little bit just to save time. You must consider the circumstances by which he was surrounded at the time of the force. The danger need not have been actual, However, to justify the use or threatened use of deadly force, the appearance of danger must have been so real that a reasonably cautious and prudent person under the same circumstances would have believed that the danger could be avoided only through the use of force or threat of force. So it kind of boils down to the testimony that's been provided so far. Are the fears that Mr. Lambert had that in this statute is an objective, not a subjective standard for stand your ground. But would an objectively reasonable person that is trying to exit by a man who has already previously been involved in some type of scuffle that we couldn't see off the screen because there's no video for that, with a whole bunch of friends who are acting all.
So what was the testimony about the scuffle that happened off the screen? What did the alleged victim do? What is the evidence of that?
We don't have any testimony about that today, Judge.
Okay.
But that is not the test. The test is at the time immediately before Mr. Lambert hit Mr. Hennessy, did he have a reasonable basis for having a fear of serious injury or bodily harm? And confronting a man who is standing there with his hand under his shirt, with his non-gun hand back, and he's standing in the video that we've seen, with his hand underneath his shirt. The only time in this whole process that we've seen him standing there with his hand under his shirt in a position, and then there's no contradicting testimony at all that Mr. Hennessy said to my client, "I've got something for his ass." Now, was that directed at my client? Was that directed at Tyler, his friend? I don't know, but when anybody in law enforcement confronts somebody that's standing there in an altercation, that's standing like they're about to draw a weapon, and a man says, "I've got something for his ass," I think it's reasonable to use self-defense. And I don't know if you're going to spend any time going back and looking at the video or not, but
I've watched it quite a few times
I know.
while you've been here. Yes.
And but you will see that the grip on the bottle, it's very hard to see, but the grip on the bottle did not change until there was some recognition between those two. And that's probably at the time that something was said, or that Mr. Lambert actually sees him with his hand under his shirt. That is not a withdrawing way to stand. A withdrawing way to stand, if you're trying not to engage somebody in any further action, is to stand with your hands out like this so somebody can see your hands, that you're not a threat, or hey, I'm not causing any trouble here, or stand with your hands down here. But when somebody's in a drawing posture like this, it is reasonable for somebody, especially that has knowledge because he has a carry and concealed weapon license, that has training, that is a draw posture for a firearm or a knife. Textbook. And so I believe it's reasonable, even if he's mistaken, and the jury instructions allows for the threat not to be actual. It allows for somebody to have a mistaken perception that it doesn't end up being true that somebody has a weapon, but if somebody acts in self-defense, even if they're mistaken about it, as long as their belief was based on a reasonable basis, then they are immune from prosecution. And if I can, Judge, I'm sure that everybody has seen this case, so I didn't send it around. It's one of the similar cases on Stand Your Ground. It's the Bowie case. I'm sure everybody's familiar with it. I want to read a little bit from the Bowie case, which is 292 Southern 3rd, 471. And I'm probably going to get it looks like it's in Westlaw Box 12, 13, 14. But when it talks about, and this was a case where a case was thrown out based on Stand Your Ground in a not too dissimilar altercation that was shooting that. Clear and convincing evidence, which is the proof that the state has to bring forward in order to meet their burden, requires that evidence must be found to be credible. The facts the witnesses testify must be distinctly remembered. Mr. Hennessy did not distinctly remember any of the facts or what he said, and couldn't even deny that he had said something threatening to my client. Moving on in the quote, The witnesses must be lacking in confusion as to the facts in issue. And that's talking about whether the state is able to meet their clear and convincing burden. In this case, they have presented no witnesses that can, I'm sorry, Judge, that have been able to have credible facts, distinctly remembered. Explicit witnesses must be lacking in confusion to the facts at issue. The only person who's presented that has been the defense through Mr. Lambert's testimony. Mr. Hennessy cannot remember or even deny that he said something. The test in the Bowie case, the court goes on to say, furthermore, the trial court did not resolve the differing accounts of how the altercation transpired, and the evidence adduced at the stand your ground hearing was highly uncertain and conflicting, leaving the state unable to meet its burden. And I'll close on this, Judge. The first paragraph of the conclusion in the Bowie case really speaks as to the passion of these cases, because obviously tensions are very high. Everybody's passionate about this young man. He's got a big cut on his face. And the court seems to suggest that we need to look beyond that and look to what it points out here. And this says, one can reasonably look at the facts of this case and say that it is not one in which the defendant deserves, in a moral or public policy sense, to be immune from criminal prosecution. In other words, in the Bowie case, the facts look bad or look scary. Whether the defendant deserves immunity in a moral or public policy sense, however, is not the question that the stand your ground law requires us to answer. The legislature has directed that a defendant who files a sufficient motion to dismiss on grounds of immunity is entitled to it unless the state clearly and convincingly establishes that he is not. The only evidence has come from Mr. Hennessy. He states he can't remember. That is not clear and convincing evidence. We have rebutted that by stating that Mr. Lambert had a reasonable belief that he was in fear for his bodily safety and that of his friends, and we're asking for you to dismiss the case.
The thing that makes it so difficult for the court, and it was intended by the legislature, I'm sure, is the burden of proof that the court has to find, be clear and convincing. If it wasn't for that, if it was a lesser burden, it'd be a lot easier for the court. But the clear and convincing certainly shifts a huge burden on the state. And so that's what slows the court down. The only evidence is not just the testimony of the defendant, it's the video. Would have been a lot easier decision for the court to rule in favor of the state if the defendant didn't take the stand. The defendant taking the stand and saying, that the alleged victim stated, I have something for his ass, that's what slows the court down a great deal in relation to clear and convincing evidence. But if the court boils it down, it's saying that an alleged victim that puts his hand on the hip or has the posture that's in the video, an alleged victim's friend gets into a fight. The alleged victim says, I have something for your ass, and then the defendant gets to hit him with a beer bottle. Is it clear and convincing evidence that the defendant is justified in using or threatening to use force, except deadly force, against another when and to the extent that the defendant reasonably believes that such conduct is necessary to defend himself or herself or another against the other's imminent use of unlawful force? The court finds that that the state, and I'm going to get this in a double negative, so I don't want to do that. By clear and convincing evidence, the state has overcome the immunity arising from that sentence. Then, as Mr. Klotz points out, there's a parade too. A person, meaning the defendant, is justified in using or threatening to use, well, that's only deadly force, I'm sorry. So, again, a difficult decision for the court. The video is the thing that carries a lot of weight. It is undisputed on what the terminology was, what was said by the alleged victim. There's no dispute of that. But is that in relation to the other facts of the case? Does that allow the defendant to prevail, especially in light of the relatively low burden? And the defendant doesn't have any burden, the state's got the burden. The court finds that by clear and convincing evidence, the state did overcome the immunity, so the motion to dismiss under stand your ground respectfully is denied. So Mr. Gomez, if you'll prepare a proposed order on that, if you'll prepare it in Word, provide it to Mr. Klotz within 5 working days from today. If the two of you can't agree on the proposed language, Mr. Klotz, if you'll provide the court and Mr. Gomez with a red line of that order. So I'll see, Mr. Lambert, is it on May 8th?
Well, Your Honor, may I address the court?
Set for Monday? Okay, yes, sir.
Your Honor, when I have appealed these types of cases before, I'll file a writ of prohibition. Because it is an issue of whether he's immune or not, we would ask for a continuance until I'm able to file the writ of prohibition. I think that would stay it anyway, at least it has in the other cases that I've had in this particular situation, and that would be our intent. So I'm asking the date that you have said, May 8th, is that a trial date or a docket day? Or
well, our docket day is Monday, the 20th. Right. I think that's when we're set at this point.
Knowing that I'm going
I think we were set Monday, and then I think, did we set it for? Because we came up Monday, and I think we said.
Okay.
We said we'd leave it open until today.
Right, because I didn't want it to totally fall off the radar. If it was going to be continued one cycle, it would be May 8th. Is that enough?
That'll give us time, Your Honor. Thank you.
Okay.
May we?
No objection.
Okay. Please, yes, sir. You'll get that, Madam Clerk.
May we approach, Judge?
Yes, sir.